I beg pardon to mention that previously with particular IA, for there it by law delisted. It is delisted.
What is there?
Previously it is in the list, but it is delisted. I'm glad that 14th.
On
14th.
14th. Today is 12th. Why not tomorrow?
There tomorrow I will not available.
That is the whole. So you cannot fix the.
Yes. Okay.
We will see. We are not assuring you why it has been delisted. We don't know, but we will see what can be done. Please give your step.
So except tomorrow, any other day is all right. Check for the for date fix college.
Tender. The petitioner in this content question has challenged for non-compliance of order dated 2/4/2022.
How many slips are you having?
3 matter.
3 mentioning 0.
Matter.
Okay.
All are tender matter.
All tender matter.
But you're saying it's a contempt.
2 contempt and one for fresh.
Rest you mentioned first. Contempt there is no objection.
Miller. Petitioner is the highest bidder and after depositing of APS and ISD allowed withdrawal of agreement.
All right. We will give your slips, we will see.
Obliged. Can we be pardoned by
I may be pardoned for mentioning one. I may be pardoned for mentioning one matter. My lord, this matter was initially filed as a PIL. It was dismissed with a cost of 20,000, stating that it's a service matter. So I filed one, again I filed this as a service matter. It was before Justice R.K. Patnaik. Now it was returned stating that it's a PIL, he cannot take up that matter. So may I pray this matter to come out tomorrow? It's been 1 year, I am just, the petitioner is.
We will see the file. Paid on. 20,000 you have paid.
It was waived actually.
Huh?
It was waived by an interim application.
You want again. You want that cost to be imposed again.
No violence.
No, all right.
But there are.
May I be permitted to mention, my lords?
To that tabling of the Justice Raghuvir's commission report. It was before 1 month, but it not getting listed.
Give your slips.
Another also that relating to.
Please give your slips.
May I be permitted to mention, my lords? I'm through VC, my lords.
Yes, please.
My lords, I may not be mistaken, but I'm constrained to make this submission, my lords. It is with respect to bail application number 5616 of 2024, my lords. It was filed in the month and thereafter it was listed before the Honorable His Lordship Justice A.K. Mahapatra, my lords. It was last heard on 27th of June 2024 on which date His Lordship passed a direction that the matter has to be listed in the first week of July. Thereafter, multiple memos has been filed, multiple mentioning has been made, but the matter is not taken up, my lords.
Where have you made the mention?
Before His Lordship, before His Lordship Justice A.K. Mahapatra, in the court of Justice A.K. Mahapatra.
What matter? Is it a bail matter?
Yes, my lords. It's a bail matter.
Is his lordship hearing memos? You have said that you have made mention for listing of your case before his lordship. Are you sure that he is listening to these mentions? Or he has said that they will come up in the usual course?
No. Well, even I filed mentioning memos online, but I mentioned it virtually as well, my lords, on multiple occasions.
Sorry.
I don't mention my item number 48. Item number 48, they are already heard by this honorable court, only directed to submit the notes of submission. I have submitted the notes of submission, only elaborate the notes of submission. That matter is heard on last day, item 2, but unfortunately that item is listed 48. So kindly be taken up today, madam.
That's item state appeal. The lordship has heard that matter and they have sought for time for filing up notes of sir. And I am also preparing. I will submit in course of the day.
Take my man. Take appropriate.
My lord, item number 56. My lord, taken total.
Call 48 will be called at 2 p.m.
56 years.
Let 48 finish, thereafter 56.
My lord, 56, my
All right, your matter will be called at 2 p.m.
Item 56. Last time mentioned lordship. Urgent matter.
What?
That's to do tender lordship. I am the tender continue the work lordship. But due to rescission proposal lordship, I have been lordship restrained to complete the work lordship. And now they have come up with new tender.
What?
Rescinded.
I had mentioned on last Thursday lordship.
You asked to mention today.
Lordship.
So we can take up tomorrow at 2 p.m.
At 2 p.m. lordship.
tomorrow.
Lordship grateful lordship.
Item number 2.
The total matter by for the last order 24/7, your lordship had directed us to approach the managing director. The managing director we have approached, but now it is in the hand. They say that the financial decision has to be taken by the chairman. They have forwarded all the papers to the chairman. So chairman will take a call now. I was talking with Mr.
Please, don't.
Your lordship, I am appearing. on
He
behalf of
also
my
says that
learned senior.
some time may be given so that the chairman can take a decision. In your order, your lordship had mentioned managing director. So managing director has forwarded it to the chairman. Chairman will take a decision because it's a financial matter. Lordship
It
will
is
give
stated
some.
by learned counsel appearing on behalf of the senior counsel appearing on behalf of the petitioner that in the light of this court's order dated 24/7/2024, the managing director INCO has sent a proposal. Chairman INCO in view of the dispute having financial implications. And the chairman has now to take a final call. Full stop. List this matter on 4 weeks.
4 weeks.
Retaining its position.
Court expects managing director.
Interim order.
List the matter on 4 weeks. The interim order shall continue in the meanwhile. Yes, Miss, you are appearing for whom?
Opposite party number 2 and 3 on behalf of my learned senior, Mr. Gautam Mukherjee.
All right.
Item number 1.
May I please? On the last question, my lordship, your lordship asked to file an affidavit to give a age proof of the petitioner. On last occasion, on white order dated 5/8/2024, your lordship asked age proof of the petitioner. I am filing this affidavit.
Why are you filing it here?
Why don't you file in the registry?
I'll file.
What is the date of birth?
1967. 29/1/1967.
On what basis?
The HSC certificate,
Huh?
the HSC certificate, higher secondary certificate, the
File affidavit in this.
madam.
This, this only. So, that the affidavit as directed by order dated 5/8/2024 be filed in the registry in the meanwhile.
Item number 3.
Affidavit on behalf of the petitioner be filed in the registry.
May I please, Your Lordship? The annexure 3 at page 69.
In item 3, that regarding that horizon, this matter may be taken up tomorrow.
This is what?
This is regarding that horizontal reservation for sports person,
Yes.
No.
physical handicap persons.
Ah.
So Your Lordship on last occasion has directed for to be prepared on that certain judgments may prep for tomorrow because that
All
file was
It will
misplaced.
come tomorrow. As requested on behalf of the
Horizontal
state. This matter tomorrow.
Item number 4.
Please examine that, Mr.
Yes, my entire problem, my file was misplaced just now traced out.
May I please? That the petitioner placed for an opportunity of hearing before the London single judge. Initially in the year 2012, an original application was filed before the London Tribunal with certain challenging the penalty matter. Penalty was withholding of 50% of pension. Now since the interim order was not passed in my favor to release the balance 50%, I came up to this annual court. In the process, whole prayer in the original application was being adjudicated by the DB1. Yeah.
When the OA was pending before the tribunal, the DB here was.
DB here was pending.
No. So DB was adjudicating the
Entire-
on the.
Entire prayer merit because the pension, withdrawal of pension, whether it is to be 50% or whole 100%, that was to be adjudicated. That's why this honorable court counter agenda, everything was filed. Ultimately, in August 2019, the tribunal was abolished.
Is that pending?
That has been disposed of or pending? The writ petition on which you are facing reliance, is that pending?
No, my lord, it was disposed upon 14/11/2019.
But you've not given any of the orders, I think.
It was annexed in the petition. I am handing over a copy itself.
No, why will you hand it over?
It was in the order, in the brief itself.
4675 of 2012.
So,
If you have annexed. You have annexed the order
it was annexed before the London single judge.
and single judge it was the next.
My lord, it will be
Where is the order?
fixed.
Let us see the order.
In IA number 124.
The order which you have imposed, impugned.
My lord, at page 23.
Twenty-three.
But here you are challenging the order where the learned single judge had dismissed, stating that it cannot be restored after 11 years.
My lord. The counter was also not filed by the government.
What is the counter for 11 years? What is the counter?
No, in the original application.
But that has been dismissed long back, before abolition of the tribunal. Right.
In the meantime, this honorable court DB1 was adjudicating the matter. And this honorable court directed to adjudication on merit.
What is the purpose of restoration application?
My lord, the penalty order will stand against me, my lord.
So, but it is because of you. It is because of you that it was dismissed.
I couldn't address your lordship properly.
Huh.
In the year 2012, I challenged the order of penalty before the London Tribunal. Penalty was 50% withdrawal of the pension. Now the London Tribunal didn't grant me any interim order with regard to release of balance. So I came up to this annual court in 4675 of 2012. During in the process of adjudication, whole prayer in the original application as was made before the London Tribunal was being adjudicated. Counter was also filed. Rejoinder was also filed. In the meantime, before the London Tribunal, the original case was dismissed for default, which I didn't know. There, in the 2019, this annual court directed, my lord, on 14/11/2019, after abolition of the London Tribunal in August 2019, the prayer was quoted. Thereafter, in para 3, submissions made by the London Council for the petitioner, and in view of the abolition of the tribunal, the petitioner is permitted to file an application for the registry of the tribunal along with certificate of this order for transfer of the original application to the High Court for adjudication of the same before the assigned bench. Now it has, after the abolition, the matter became single bench. That's why this honorable, you should kindly have a look. We need an opportunity of hearing, my lord, on adjudication on merit.
Mr. Counsel, when was your application dismissed?
It was sometimes in 2012.
Your application was dismissed in 2012.
During pendency of the writ petition.
Just a minute. So you'll have to seek review of this order first. Because this order was passed, the division bench order was passed under the impression that this application is pending.
No, it was pointed out to the DB1, my lord. In the petition itself, I stated that the application was dismissed for default. The Honorable Chief Justice then directed me, we are dying from merit.
Adjudication on merit? Where is the question of adjudication on merit? This application, this order was passed for transferring the original application to the High Court.
My lord.
Original application was dismissed. So this order was passed under the misconception that the application was not dismissed.
Yes.
So you seek review of this order.
The impugned order, my lord.
This order, the division bench, order of the division bench. For disposal of cases were also transferred. Oh, how disposal of case can be transferred?
No,
No. A case which are disposed of before the tribunal that has not been transferred. See, your lordship pointed that whoever was dismissed on 2/4/2012. So without pursuing the remedy there for restoration, as my friend has pursued the matter which was pending, he has come against the interim order.
Because of that is all right. Because of this order, that is what is being mentioned, that you brought to the notice of this court.
Yes, ma'am. That is under misconception that as if that matter is pending.
That is why when did you file the IA for restoration in that after the file came here?
No,
2021.
2017. So that was after 5 years or whatever.
2017 you filed what? Restoration.
For restoration.
Where?
To the learned tribunal.
So whether that restoration matter was transferred?
No, yes. That itself was adjudicated.
That was ultimately dismissed.
That was
here.
ultimately dismissed.
Where is that?
At page 23, my lord.
At page 23 is something else. Mister,
The IA number 308721. This number is the assigned is the High Court by the High Court.
Sorry?
How do you say that original file? How do you say that this IA was filed in 2017?
My lord, it was listed in the application itself.
Is 2021.
No, then it can't be because all numbers, they are given the same year, same number, only the nomenclature is different. So how are you saying 17? Must be 21.
No. 21 by then the tribunal was abolished.
Mr. All right, Mr. C, this order does not indicate that the application which you had filed before the tribunal was default. This order was passed in 2019.
2019.
So the division bench was not aware of the fact that your original application was dismissed for default.
Yes. But subject to acceptance of your lordships, you've been accepting for a movement that the application was dismissed for default. Now I pray, my lord, in view of the prejudices, this can be restored to the file for adjudication on merit.
We don't know. Your conductor is also required to be gone into. All right. We'll see. This matter along with the records of WPC or OSC.
No, WPC 4675.
WPC 4675 2012.
WPC number 4675 of 2012, that will not do. That will not do. All right. And when you file your action for restoration in 2017, why didn't you tell the court?
I told, my lord.
You told?
I told before then it was dismissed for
you will
default.
have to lead evidence.
I am sorry, my lord. My lord, then the ultimately direction was since after abolition
You
of
had
tribunal.
told and
The petitioner is now 80 years old. And the pension will be not. He will not be getting pension.
blame yourself. Yes, next. 1 week.
Item number 5.
I pray for an adjournment.
Why?
Madam, Mr. Arguing counsel, Mr. Rajdeep Agarwal is not available today. Yeah, transfer brief, my lord.
All right. What is this matter about?
I pray, can you keep it on 21st?
We will not.
Sorry, ma'am.
Not going to learn counsel appearing on behalf of the appellant states that there is no urgency in the matter. Stop. He requests adjournment. List this matter on 8 weeks.
Item number 6.
It will come up next week.
One.
Item number 6.
May I please, yours? By the order of the Honorable Single Judge, at page, it starts from my lord, the page, annexure 6, page 31,
Yes.
is under challenge. But the fact is, the petitioner was initially appointed as Shiksha Sevi Shiksha Sahayak. While continuing, my lord, there was a direction by this Honorable Court holding that all those are null and void. And direction was issued by the government, my lord, to cause a fresh selection. We appeared, my lord, in the fresh selection also. My name was also appeared at serial number 47 of the provisional list. But while issuing final list, my lord, my name was not there. And in the meantime, my lord, pursuant to the direction of this Honorable Court, my lord, we continued in service. it was my specific case, my lord, before the Honorable Single Judge, which has also been reflected by the Honorable Single Judge, that I was in the second list. And but the relevant portion, my lord, if you also look at page 47, my lord, para 34.
Please come to para 41 and 42.
Well, when the recruitment process is declared null and void in WPC number 11748 of 2003, the petitioner is ceased to be an employee of the Sikasaya, and even though he was allowed to work for said period, cannot be counted. Government also directed all the collector to disengage the successive shares to engage after 2693 and not selected subsequently. When SLP number was dismissed by the Supreme Court, there is no necessity of issuing a so-called notice or to hear the petitioner personally. Only the orders of the court have been carried out. Though the petitioner got appointment on the basis of selection, the process of recruitment has been declared null and void by the court. Moreover, the government made a policy decision to disengage them. Hence, there is no need of personal hearing. Additionally, after disposal of WPC number when the engagement of Sikasaya after 26/9/2003 was declared null and void, 7187 persons were reselected for engagement. 23/12/2004. Passed in WPC number 13958 of 2004, and batch of cases directed that the Swechhasevi who have not been reselected in the current merit list shall continue until further orders. As such, the petitioner continued service. Therefore, the order of disengagement is not illegal. With the aforesaid discussion, the court is not inclined to entertain the petition.
What's wrong?
The wrong, my lord, in the second list, I was also selected as a fresh in-service candidate.
Yes.
If you also look at my lord, is there para 9, my lord, page 39.
Page
39 of the judgment.
here.
In the said selection, but this is the second selection, my lord, found at place 47 of the provisional select list of the candidates for engagement as Swechhasevi Swayamsevak for Rayanpur Education District dated 10/12/2004. In the list, name of the petitioner was
Which paragraph you are reading?
para 9, my lord,
Yes.
page 39 of the impugned judgment.
Yes.
In the said selection, this selection was the subsequent selection which was carried out. Petitioner name found place at serial number 47, the provisional select list of the candidate for engagement as Swechhasevi Sikasaya Education District dated 10/12/2004. In the list, the name of the petitioner was included as an in-service candidate. In the said provisional selection list, it has been shown that vacancy of ST male is 57. The final selection list was published on 31/12/2004. And in the said list, the total vacancies of ST male was shown 61. Further, no name was mentioned in the said list that who were the candidates selected against those 61 vacancies meant for ST male candidate. But in the bottom of the final list, it has been mentioned that 61 posts are reserved for in-service candidates. As the serial number 46 of the provisional select list as an in-service candidate, the petitioner is selected as an in-service candidate in the final list, as all 61 persons are reserved for in-service candidate. So based on that, my lord, we are allowed to continue in service. So that aspect, my lord, though it was indicated in the fact, but not been taken note of.
No, that. Yes, is it?
I'm
it correct?
estimate
Where is the finding that your name was there amongst 4187?
My lord, page 34, para 34, page 47. Referring to the facts, my lord.
If your name was there, then what was your relief sought?
Relief sought, my lord, because there was a disengagement, direct disengagement.
Direct disengagement because the selection process was found to be null and void.
Well, I'm not challenging that, my lord. I was selected in the subsequent selection.
So what was your relief?
Relief, my lord, to pass that selection because it was even natural justice was not violated. While disengagement.
Your cases, your name was there in the provisional list, and the final list, it was not there.
Not there.
So what
Because
you read out now was your submission.
Yes, madam. That's a fact, madam. That's a fact because in the final list it was indicated ST male was 61.
No, that you said, that means you are selected.
Yes.
That is your submission.
Yes, madam. That was my submission. And para 34, my lord, has also taken note of that. It is not a fact that the petitioner has been
So is this your case that your selection was not found to be null and void?
Yes.
After a selection was to be null and void.
Yes,
Reselection was done.
Yes.
And in the reselection, you were
selected as the in-service candidate because in the first selection also I was selected. So those were, my lord, it was they held to be null and void. And after the matter was went to Supreme Court and Supreme Court SLP was dismissed. Thereafter, my lord, direction was issued, disengage all those. But in the meantime, my lord, I was selected in the second selection. My name was there at Series 47. And I continued, my lord, for 14 years of service.
and you were appointed thereafter.
Yes,
You were engaged thereafter.
yes, my lord.
Yes.
Still also, see para 22 of that page 43 of that writ appeal. Ma'am.
Yes.
It is false to say that Dasarath Hembram appellant was selected for the post of Shiksha Sekretary pursuant to
Paragraph?
the paragraph 22, my lord. This was the submission
Yes.
of the opposite party. It starts at page 43, last part.
Yes.
The selection process was with respect to the advertisement 2003 was completed by the end of August 2003. In fact, the petitioner got engagement order on 10 to 2004 in view of the government notification dated 26/9/2003. This posting was made out of the list of prepared pursuant to advertisement dated 25/3/2003. Well, I'm pausing there. But this selection process was challenged and these appointments beyond the advertisement was challenged. And your lordship declared that appointment is null and void.
And then paragraph 23 is also there.
Yes, my lord. The petitioner made a fresh application for the post of such Fresh was issued after decision and application number by the court. The petition was provisional for the post of name was placed at serial number 47 in the provision. However, he was not selected when the final list was prepared because as per the merit, he did not come with that position, my lord.
My case, my lord, when the final list was published, my name was not there because I was there in the first select list. That's why, my lord, as an in-service candidate, I was permitted to appear. I was selected so and so, and 61 posts were available, my lord, for ST male. That's why specific case, my lord. And after 3 years, my lord, I was regularized as junior teacher.
All right, we'll see it tomorrow.
Right.
Item number 7.
Item 7, my lord.
Well, only subject to your lordship, sir.
Tomorrow.
Item 7 may pray for day after tomorrow, my lord.
It will come tomorrow. Otherwise, why?
No, my lord, 7. Item 7. No, not 6. 7. The state appeal. State appeal day after tomorrow.
Yes.
Item number 8.
That's the day after tomorrow.
And for the appellant, my lord, here on the last page, I'll be submitting the additional counter affidavit today on the registered tomorrow.
You were given time.
But today I see that.
Yes, Mr. Batra.
Last occasion, Lordship entertained the writ appeal and he wanted time. So, my lord, interim order is there till today.
As requested
Have you served copy?
by
Yes.
the respondent in person. Place this matter on 1 week.
Oh, if you have served copy, he has to go through that also.
We will take Mr.
On 1 week. He states that he is going to file the additional affidavit in course of the day. In course of the day. The affidavit has been served upon learned counsel for the appellate. Yes.
Interim order may be extended.
Item
Interim
9.
order may be extended.
No, interim order shall continue in the.
Item number 9.
Yeah, please.
This is a review petition, my lord. Seeking review of order dated 18 June 2024, my lord. my lord, at the outset, my lord, with utmost respect, my lord, three things saved attention of this court, my lord. My lord has held in para 4 of the order that being a legal heir, I am not entitled to pursue the application filed by my late father, my lord. To that, my lord, there is a rule 58.
Just a minute. Which part?
My lord, para 4 I am reading, my lord, of the order, 18 June 2014 order, my lord, passed by my lord. We see no illegality in the impugned communication dated so and so, as noted above. Case petitioner who is legal heir of P. Bengal Rao does not have right to pursue this matter as said communication relates to rejection of an application for QL. I have copy of the rules, my lord. May I pass on that rule, my lord? And I have quoted that rule in para 5.1 of my petition, my lord, of the review petition. Give that rule, 2004 OMC rules. The 58, my lord, clearly says para 58, rule 58 says, my lord, may I read that? I have quoted in para, this is minor mineral rules, quoted in para 5.1, my lord. It says that where an application for grant of renewal or prospecting license or mining lease or quarry lease is before the order granting him or license or lease or its renewal is passed, the application for grant or renewal of lease license shall be deemed to have been made by his legal representatives. So rule itself creates a deeming fiction, my lord. And the factual background is that my father died on 9 January 2005. I immediately informed the government and applied for legal heir status. Legal heir status was allowed also. They communicated to me as a son of late Mr. Bengal Rao, but in this case, I don't know for what reason they have not communicated neither the notice nor the order, my lord. So this notice and order was never communicated to me.
This was not the point taken.
That's why, my lord, I'm sorry.
No, that was not the point taken. The point which was taken was, this was a communication was of 2008, 4/1/2008.
Yes.
All right.
Yes.
His submission was that the order is null and void because he is a dead person.
I'm coming to that. Coming to that.
All right.
Also.
That was the only point argued. And then that is...
That's my fault, my lord. I said with due humility that it's my fault that I could not place this rule before my lord.
No.
So that's why I mean,
forget second part. Forget second part. This is of 2008.
Yes,
you are approaching in 2024.
I'm coming to I have some answer to that. My answer to this is, my lord, that he died on 9 January. My lord, I have applied for substitution, submitted 3 documents, death certificate, the legal certificate.
Where?
My lord, and that is before the DDM.
Then why didn't you come here in 2009?
My lord, 2009, I was not aware that it is rejected. Let me give those facts, my lord. 2000 he applies, 2005 he dies. 2005, there is a huge rise in Naxal activities in that area. This area is bordering of Sukma district. I had to leave that area. I was operating other lease in that area itself. I had to leave that area. All businessmen ran away.
So have you stated all these facts?
Yes, my lord.
In your petition?
Yes.
Your petition?
Yes. And I have said so. And my lord, then while this Naxalism receded, and the collector filed his report in 2020.
The rules first. Let us see the rules first.
Yes, Rule 58, my lord. That is the rule 2004. OMMC rule 2004. Rule 58. A status of grant on death of application for prospecting license, mining lease or quarry lease. where an application for grant or renewal of prospecting license, mining lease or quarry lease dies before order granting him or renewal is passed, the application of lease shall be deemed to have been made by his legal heirs representative, where an application in respect of whom order granting or renewing prospecting license, mining lease or quarry lease is passed, dies before deed is executed, the order shall be deemed to have been passed in the name of legal heir of the deceased. So one of the ground that I am not entitled would not have come if this rule was placed.
All right. Even if we accept your submission.
Yes.
What explanation do you have for what 16 years
I'm
after?
deeply obliged,
the-
my lord. I'm deeply obliged, my lord. My to that my answer is, my lord, that this notice and order was never communicated to me. When the Naxalism was on the peak, my lord, everybody has to leave. I had to leave my all belongings, my stocks, everything, because I was working in other area. There are two areas. One lease was granted.
All right,
I was
let
working.
us see the.
So when
the
I
pleadings.
ran away, my lord,
Let
then
us see the pleadings.
yes, my lord. In
Petition,
the yes, my lord may come to writ petition, my lord. And the grounds in para 6, I have said how I have come to know about the order. The facts, my lord, are given in okay. Yes. Naxalism was there, my lord. I had to leave. Then, Lord, 6.1, his file application. Then application intimated. Then that all areas as per 90. Then para 6.4, it was received. Para 6.5, 2000. Then DDM Puraput asked Tahsildar to submit report. Then para 6.7, DDM 5 Tahsildar submitted report para 6.8. Then this goes up to 2005, my lord. Then para 6.16, 2005 comes and he dies. Is 6.23, I have said that Naxalism and all, my lord. This area is Malkangiri. This is bordering to Sukma district, that is hotbed of Naxalism, my lord. And then I have para 6.24, I have said that Naxal activities were going on. There was 37 Naxal incidents that continued up to 2018. The last report the collector gives on 12th of 2023, that is an excess 17 series. I have an exploit. When this Naxalism resided, the businessmen started coming back. I came back for revival of that lease, because other lease they have lapsed because of non-working during this period. When I was seeking revival, they have made a passing reference that I have also considered your other lease. Then I applied RTI. That RTI application is page 99, my lord. And in RTI, they have said on 9 January, that page 99 and Annexure 18, my lord. The RTI, they have replied, and they are saying that the 4/1/2008 is the last communication between you and the government. So that is why I come to know on January 2024, and I file a writ petition. They are not giving documents. Documents are missing. Meanwhile, my lord, I filed this writ petition.
All right, let them file affidavit.
Yes,
We'll see.
deeply obliged. Yes. Para 6.2. That is a fact, my lord. In grounds also, I'll The end I have said, my lord, already. I have given representation.
Or the granting of the order. And so whereas there is no provision for grant of equivalent equality was stored under OMC.
And in any case, I see that the order against dead person.
Forget that.
Yes.
Forget that. Now come to this, the order which has been quoted.
Yes, my lord.
There is no provision for grant of QL decorative stone under OMMC rules 2004. And the applicant does not fulfill the requirement for grant of PL under the existing rules now in force.
Lord, there is no reason for the two reason has been cited. The para below that the report of DFO and Tahsildar has not been submitted. That is factually incorrect, my lord. Annexure 5, page 78 of my writ petition is report of the Tahsildar, and Annexure 6, page
No, what
79
about
is
this? What about first thing? No provision for grant of QL decorative stone under OMMC rules?
Lord, now for some time this mineral became my major mineral, then it became again, it's still a minor mineral.
Where is the question? When the order was passed, whether there was provision for or not? That is the question.
That order is without any basis, my lord. I will demonstrate. There was a
Demonstrate
provision.
right now.
There was a provision. The OMMC, I applied for under OMMC
See, first
rules,
come
my
to
lord.
the first paragraph.
Yes.
Whereas there is no provision, where is the provision?
My lord, that OMMC rules to 1990 I applied under. OMC rule says that query lease application will be decided within 6 months. Government was sitting over. Now, for without any reason, they are saying there is no provision for query lease. Now, I don't know what that does mean, my lord. Today, even today, there is a provision under Orissa minor mineral rules.
When the order was passed, there was such provision or not?
There was such.
We are testing the legality of
There
that.
was such provision, my lord, because they might be thinking that quarry lease and mining lease is different thing. Only nomenclature may be different, my lord. The quarry lease, when it is granted for excavation of quarry lease, when it is granted for major, it is called mining lease. But there is a provision for grant of mining lease and quarry lease today. So there is no qualitative difference. Only nomenclature may be different. Quarry is for excavation of minor mineral. Mining lease when it is given for major mineral like coal and iron ore. So maybe they are saying that technically QL what is not there, ML what might have come, that I've examined. But under OMMC rules 1990, which applies to me.
And let them file affidavit.
Deeply obliged.
Issue notice. Who accepts notice?
Procedural.
File affidavit. 8 weeks.
No. My month is not there, so that's why I'm not served.
Deeply obliged.
Item number 10.
Last opinion.
Lordship said directed me to file an affidavit. I have, it's a, yeah, Lordship directed me to file an affidavit with regard to that. I have received instruction. I will file affidavit in the meantime. Lord.
How much?
2 weeks time I can file that.
2 weeks further time is allowed for the state to file. Counter affidavit. When was the order passed for filing counter affidavit?
Lordship said, please to pass the order on 6 April.
6 April.
6
April. April.
And we are in August.
Right.
What is this matter about?
This is relating to scarcity of water, drinking water, and a project, my lord.
Drinking water?
No, they want a minor irrigation project to be excavated and similar place in their locality.
We'll make it clear that if no affidavit is filed by the next date, the court will consider imposing cost.
Item 11.
To file after instruction statements.
But I have already obtained instruction. This case, there was an order passed by this honorable court by honorable single bench, my lords, where there was a direction to go on for construction of the Anganwadi center, my lords, which they have now challenging before lordships, my lords. The petitioner, who is here, my lords, says petition number 2. If you also kindly look at this, my lords, cost title.
So time was granted to you to file affidavit.
Yes, I have obtained instruction, I will file that affidavit, but they suppress the fact. Petitioner number 2, who was a petitioner before the honorable single judge, he filed this PIL after losing in the before the honorable single judge. Case number is WPC number 26497 of 2022. And order was passed on 12th of February 2022. And this was immediately filed thereafter in March. PIL was filed.
So we will impose cost. File your affidavit.
Yes, Lord.
You should be ready. If that is the case, then we will impose exemplary cost. Withdraw. And counsel for the petitioner after some argument seeks permission to. Application is dismissed.
Item number 12.
Kindly pass over.
And requested on behalf of, this is PIL.
Yes, Lord.
Let us see. Oh, pass on PIL.
Lords, come to the Lord's prayer portion at page 24. Player number 1. Page 24. As to why a writ of certiorari should not be issued to quash the MOU dated 20th of April 1991 and this held date dated 5/1/1994.
Kindly pass over.
Pass over, no pass over.
And after loss.
Not even for a second.
And the petitioner challenging the inaction of the OP number 3.
Challenging? Who are you?
Challenging the inaction of the OP number 3.
Who are you?
We are the villagers, madam.
Villagers.
My lord. Well, kindly see
Which
the Annexure
village?
6, my lord.
Which village?
Well, Annexure 6 to be disposed of by the OP number 3, which is the order of the not an action on the order of the collector, madam. Kindly see page 73, madam. Page 73. Mary. Protection of valuable government land. This is the letter of the collector to the secretary. Industry.
And how many writ applications have you filed so far in this connection?
So in this connection, no writ petition has filed.
No.
They are for other reasons, madam.
For other reasons.
That her number, that is a company filed against inaction of some people.
Also page 65.
Next,
This
seems
one-
to be disposed of by the OP number 3. Because for protection of government land, the collector has written that there are, my senior with that.
Here, my lord, kindly have a glance to Annexure 6, the inquiry report of the collector, 73. our main grievance from this collector report. 73, page 73, the collector addressed it to the Principal Secretary of Government Industry Department. Protection of valuable government land in Chaudwar under Tangi Chaudwar, Tahsil, leased out initially in favor of Titlagarh Paper Mill and subsequently transferred to Balarpur Industries for industrial purpose. Industry Department at so and so. Tahsildar recommended that there are a lot of irregularities, and finally, in concluding paragraph, he has stated, page 77, para 70, as this instance case involves protection of valuable government land, the records of land available with us show legal anomalies and factual discrepancies, and as there is strong public resentment due to the land being not used by the Balarpur Industries for industrial purpose, it is suggested as follows. Balarpur Industry may kindly use all original records in respect of the said land. A committee under the chairmanship of a senior officer may kindly be constituted to verify all the records.
All right, we'll see.
Yes.
File affidavit.
Yeah.
Now, 8 weeks time is allowed for the estate to file counter affidavit dealing specifically with the communication made by the collector Katak addressed to the Principal Secretary to the Government of Industries Department, Odisha, dated 6/6/2020, bracketed annexure 6 to the writ application. That's this case on 8 weeks.
My lord, may I pray that they are alienating the land,
All right, we'll see.
not to create any third party
8
interest.
weeks, 8 weeks.
Item 13.
No, a letter I have given, the Tahsildar letter, they are alienating.
Item 13.
13, your lordship, within the 10 days time will be given to file an affidavit.
By way of last indulgence, 2 weeks time is allowed for the estate to file counter affidavit.
Item 14.
Wait, please, members. 14 is regarding the NOC of the.
This matter is covered.
Yes, ma'am.
That's my lord passed the renewal that.
Covered by your lordship.
That covered it. I have given the list. Covered it.
That's one.
It's offline.
Hard copy.
Hard copy 14.
Within 14 days.
That I have given the case number also.
Yes, same order.
Great.
Item 15.
Okay, pardon, your lordship, another 10 days time will be given to file a counter affidavit.
For Commissioner. Please, thank you. Further time, last time.
Item 16.
Earlier time was granted, sir.
Yes, your lordship, if sought for instructions, this week we'll file it, your lordship.
My lord, the petitioner is the head of the village to oppose the illegal action of the opposite party number 789, who have cutting the about 20 number of valuable trees in the common lands. Always in the common lands. And that has been also informed to the opposite number 1 to 6, who have not taken any action against the opposite party number 7, 8, and 9. Hence the application. I have Nomenclature.
Nomenclature. What relief will you seek?
Miller.
What is the relief which you are seeking?
Miller.
What do you want?
To direct the opposite party, more particularly the opposite party number 3 to register the case and legal action against the accused person, opposite party number 7, 8 and 9 be taken and status quo over the government land and not dispose of the government land till dispose of these proceedings. Miller? No. The area located, I'm telling, located in Chandikhal market in Mauja, Charvatia, under Khata number 260, plot number 147 area, acres on 21 decimals, and plot number 140 area, acres on 40 decimals, all total 61 decimals is a purely government land. And valuable trees were in it. That is not a personal land. The outsiders, namely Pradeep Kumar Behra, son of Kanuchan Behra, and another Nirupama Ghade, are very rowdy person.
You want, let us understand what has happened.
You want action to be taken against them. We are constantly said that the case should be registered.
My lord.
Then your prayer should not be disposed. So that is why we are asking what you want.
The direction to the
Case you could have gone and registered. Who stops you from registering a case? And for registering a case, you will come to the High Court for a direction to register a case. You go for registration of FIR.
32.
FIR registered what? Not taking any against.
Page 12, Annexure 3. And there is a 144 proceeding also, Milords. Mention is there toward the end. Bisheshta Dastravya 144 ଆପଣଙ୍କ ଦ୍ୱାରା କରିଥିଲେ ମଧ୍ୟ ସେ ଡିଭିଜନ କଥାକୁ ମାନୁନାହାନ୍ତି. Yes, and that is the order also there, Milords. Of the SDM, it is subject matter of 144 proceeding.
Do you know yourself what for you have filed the PIL?
My lord, I have also represented to the honorable colleague.
Represented, we don't know. What is your relief? What do you want?
To direct.
Do you know what do you want?
To direct the OP number 2 and 3
to
tell you. Tahsildar and IIC Dharma 3 and 4 to taken.
The IAC of the police station or what? How is the Tahsildar registered the case?
I have got.
And after 3 years, 2 years.
2 years. Miller?
It is very difficult to decipher anything from your petition and from what you are submitting.
Millard, I have already informed which is not taking any action.
So we should direct for disposal of your representation.
Millard.
That we will not do.
Millard.
That we will not do.
Millard?
That order we will not pass.
You have also not taken any action.
So this was after.
17.
Here, Lordship Miller. Fair Miller is a PIL Miller. In the Balasore district.
Yes.
In the Balasore district, Miller, the petitioners are the student guardian and one is the ex-employee of an educational institution. In the Balasore district, with fake and forgery certificates, so many teachers are. Page 29, your Lordship may kindly see, this is earlier, the matter was referred to the crime branch. The crime branch, what is there? Your Lordship may turn to page 29, Annexure 6. Last paragraph, I am stating mine.
Yes.
It is requested to cause an inquiry into the above matter and take action as deemed proper. Action taken on the matter may please to communicate to the petitioner and intimate to them. Then your Lordship may turn to page 19, Annexure 2 series. After that, my lord, the district education forwarded the letter to the headmasters of all the institutions, page 19, Annexure 2 series. It is informed me that allegations are received from Sasank Jana Airport district.
Yes, state.
Lordship, I'll take instructions and file an affidavit as to what has happened of the inquiry. I'll sit in that.
Yeah. Uh, 8 weeks time is allowed for the learned AGA and representing the estate to seek instructions and file counter affidavit. In this case, 8 weeks.
Item number 18.
Obliged.
In 18, there are several matters. I have given a list. Some item number 18, item up to 9. And then from 13, 14, 15, 16, 17, 18, 19, 21, 22, 23, these matters are coming at 2 o'clock. Similar matters taken up at 2 o'clock.
Item 60.
Item 60, 2 o'clock.
After disposal of
Item 16, 2 o'clock.
Yes,
60.
So 18 to 9.
60.
18.
60. Item 60 is at 2 o'clock. We are on item 18.
Yes, Melody, in that 18, there are some matters which I have listed, my lord. Item number 10, case number I am placing, my lord. That is sub item 18311. 18311. Next page I have given.
So this is covered.
Covered matter. Renewal matter. Military state 16986 of 24.
May I please your lordship, my lord? May I please your lordship, my lord? I am DC. My lord, serial number 18, sub item 12.
Then, my lord, item 11, 12. Sub item 11, 12.
WBC.
Yes, my lord.
This is item 1810. That is 15.10.
But then no, my lord. Then now the item number. Pardon, my lord.
One copy of the order. So I want to know what is the number of that case in which you are relying upon item 10.
Item 10 is 16986 of 86.
1770?
Yes, yes.
Yes.
My lord,
11, 12.
11, 12, then
Yes,
2024,
Yes, and no.
serial number. That is these matters have received. This is regarding the delay in not submitted within time. This matter is posted to 27th of August. So I will file the counter. Let this matter come on 27th.
WBC number.
11, 12, and
WBC number, my lord,
2024.
Yes, my 18542, 18543.
11, 12. This is what I'm saying. 11, 12.
My lord, 12 is not the similar matter, my lord.
11, 12, 2024. Item number 2024.
WPC number 18543, 18877, 191. Yes. Yes, I have given the number.
15165.
Along with
47. 18 point. Today's matter listed 18442.
Yes.
There is a typographical error.
Yes,
in your list.
I will see.
That will be
I will correct it. My lord, item 23 serial number 23, not 18. Item 23, my lord. That is regarding fire safety. I have to file counter in all the fire matters, which is coming coming on 27th also. WPC number 17932 of 24. 17932 of 24. And 18639 of 24. Yes,
23. Item number 23, not 18 sub item. Not sub item. Yes.
Yes. 60 is there. At 2 o'clock it will be taken along with those matters I have listed.
My lords, in item number 18, my lord, there is sub item number 18. In the list, my lords. I'm not aware of that list, my lords. Read number is 18877 of 2024, my lords.
Sub item?
Sub item number 18 in the main list. Please not aware of. WPC number 18877 of 2024, my lords.
I asked for time. Counter.
We are not getting.
Second page.
Number doesn't matter what you say.
List.
18877 is saying that.
List second page.
18.7. 18177. 18177.
Numbers 18877.
Page 1820.
Page 2 in the main list, my lord. In the list itself, not
List. 18877.
Yes,
my lord.
I prayed for counter.
Well, it's a fresh matter. Notice needs to be issued. If it's going to file a counter, my lord, fair enough.
I have asked.
Letter will come on 27th.
Yes. Notice may be issued so that you can file counter, my lord.
Yes,
I have served a copy on it. I have served a copy on it.
May I please your lordship, my lord?
Yes, I mentioned. I mentioned.
That he'll file counter and say he'll come up.
Yes. Sir.
May I please your lordship, my VC, my lord?
My lord.
VC, my lord.
Yes, which one? Yes.
My lord, serial number 18, sub item 12.
I may be pardon your lordship. Same item, item 18, sub items 7. WPC number 18277 of 2024. No, 7, you know.
The typographical error, there are so many.
Similar matter is that
One eight one I have written wrongly. That's 18277.
It is 18277. 18 points.
Yes, ma'am.
No, it will come.
No, that is taken at 2 o'clock.
It will be taken up.
My lord, serial number 18, sub item 12. My lord, serial number 18, sub item 12.
2 o'clock.
It's a different matter, my lord. It's pertaining to entrance. The conducting council is ill. My lord, may call for next week, my lord.
Item 12.
Item 12, sub item, serial number 18, sub item 12. 18543.
So what do you want?
My lord, next week, my lord, is pertaining to entrance of nursing college. The conducting.
The matter is coming on 27.
My lord, it's not a similar matter, my lord. It's pertaining to entrance, my lord. The conducting my lord. The conducting council is ill. Next week, my lord, any day.
What? It pertains to entrance. What entrance?
Entrance for admission in nursing colleges, my lord.
So this is what we are.
My lord.
That is the matter which you are dealing with.
My lord, he has not given a copy to me also. For the list, on rejection list, I have found it. He has not given a copy to me.
My lord, I will serve a copy.
No, because I saw that rejection order that was published, where we have mentioned for what reason we have rejected and what not. Yes.
Give him a copy.
My lord, my lord.
No, we'll see if there is. Yes.
Item number 19.
In WPC 18516, I am the petitioner. That has been filed challenging the award of work in favor of opposite party number 3. But they have filed a counter. I need some time to file a rejoinder. Okay.
And who is in the first case?
That is 18516. Mine is 18516.
No, who is in the other case? 1845.
The other one is I am there for
Senior counsel appearing in WPC number 18516 of 2023 submits that he has received that a counter affidavit filed on behalf of
MCL as well as the opposite party number 3.
Opposite parties. Counter affidavits have been received. So he needs and he seeks adjournment to file a rejoinder to the counter affidavit. So list this matter on when?
3 weeks time.
3 weeks.
the
So to enable him to file a counter affidavit. Yes.
in the second matter.
First matter.
I'm so sorry. First matter. That's the first matter is ours. In the list, ours is the first matter. But in that matter, our LOA no doubt is challenged there in that highway Mr. Mahanti. So there is no stay order. With tender of 2022, work order issued in the year 2023. I have worked for a period of 365 days on the basis of the work order issue. Thereafter, it is extended for 2 months consecutively, one of 2 spells, 2 months. They have extended it. Their reviews, their own review, MCL's own review says that my performance is outstanding, I am good. They have also given certificate to that effect. But in that second matter, taking advantage, because of the pendency of this matter, they are not further extending my work order. They MCL themselves have filed application seeking this court to extend my work order. That is page 104, in my matter, page 104. So, would your lordship like to see that? Page 104.
So
The prayer is
give a short date, Mr. Rath.
Beg pardon?
We can give a short date. Instead of
As your
3 weeks,
lordship.
we can say 2 weeks. or-
They will also obtain instruction on this.
If I'm a party, I'm a party.
No, they are not required to implement it.
Not required.
But I have made them a party in my
No,
return.
that is you have challenged my work order.
That is their
But I'll file my return in my
2
case.
weeks. 2 weeks you do. 2 weeks.
That's fine.
Retaining its position.
Would I seek a small indulgence, below? In the meantime, MCL will obtain instruction in my matter. What is the?
That you do it.
Both the matters, your lordship, place it after 2 weeks and I will get the instruction in 2 weeks.
Do it.
That will.
Item number 20.
Challenge the annexure 10 series, your lordship. I have challenged annexure 10 series, your lordship, where penalty notice has been confirmed by the appellate authority and appeal order has been passed confirming the penalty imposition of penalty upon me, your lordship. But without giving any notice or prior notice and even giving the opportunity of reasonable opportunity of hearing, your lordship, they have imposed penalty and now proceeding for blacklisting me, your lordship.
Where is the order?
Order is at page 130, starts at 130 and relevant part is 131, your lordship, where that has been recorded.
Annexure?
Annexure 10 series, your lordship. This is third time litigation, your lordship, challenging the first penalty notice. I have approached this honorable court, and again after rejection of my representation, again I have approached this honorable court, and now challenged, but they have not yet given the exact reason for what they have not considered my grievance, and till date, let's say, my revised estimate is still pending with them. They have never uttered that word in their order also.
Where?
131, you let's see the relevant part. During the
Well, see, 131 is reason order.
that is appeal order, let's see.
Yes,
And the original notice, let's see, but annexure, that is let's see, annexure 6, page 109.
No, where is the original order?
Let's see.
Where is the original order?
Pardon, let's see.
Where is the original order?
That is
the order against which you preferred the appeal.
yes, that
Where
is
is that?
annexure 6, let's see. 109 starts at page 109. The first paragraph itself may place alerts in inviting kind reference to the subject cited above, in reference to the acknowledge the final measurement recorded ex parte on 17/2/2023 positively, failing which it will be construed that you have accepted the final measurement so recorded and subsequent action will be taken for provision in the contract. But that 17/2/23 that has never issued to me, your lordship.
17 to 2023
notice has never issued to me. And what they have recorded, the final measurement.
The 17 to 2023 was ex parte. So they mentioned that it was ex parte.
That has never issued to me, your lordship. If I have received this and not attended that, then that will be ex parte. But they have never issued to me. I have never received that. In 17/2/23 notice, that is not with me. And they have written that acknowledge the final measurement when never, the work has never commenced, then final measurement, the question of final measurement will not come, your lordship, because I have not commenced the work because of the non-site clearance, your lordship.
So where is this communication about measurement on 17 to 2020?
Never I have received, your lordship. I have never received. In appeal order also, they have never ordered on that point, your lordship.
No, but what is the meaning? Come to the first paragraph of this communication, 3rd March 2020.
23.
23.
Yes, lordship.
What is in inviting kind reference to the subject cited above? In reference to acknowledge the final measurement
Yes.
recorded on 17 to 2023.
Yes, lordship. No final.
Whether after 17 to 2023, some communication was made to you.
No, your lordship, that I have challenged this 3rd March 2023 notice. Prior to that, they have referred 27/1/23, again 6/2/23 and 10/2/23. And 223 is also at page 107, your lordship, where they have given me, they have.
Yes, who is for the estate?
No, it's Orissa Tourism Development Corporation, so we cannot appear, the lordship.
No, but madam, you are alleging a violation of principles of natural justice. In the order dated 3/3/2023, in that communication. But that was not interfered with by this court. This court permitted you to prefer appeal.
After the appellate authority also upheld that notice, but without considering my grievance, lordship, because their letter at page 107 says that they have.
No, the matter would have been different had you approached the appellate authority.
Yes.
And the appellate authority, based on merits, decided your case. Then you could have taken a point that, see, the illegality at the stage of the original order could not be cured by the appellate authority. So here is a case where the High Court did not interfere to that order being violation of principles, being in violation of principles on natural justice.
Because your lordship, now my appeal order also, they have not considered my grievance, saying that, and they have never uttered a single word.
File your affidavit.
Lordship, issue notice, we cannot appear. It's a corporation, Lordship, Tourism Development Corporation.
1 week, 6 weeks. All right.
In
File
IA,
in 1 week.
may I pray for notice on IA, your lordship? My IA is pending. May I pray for?
IA
I for stay for the proceeding on appellate order, your lordship, because they will recover the amount they have demanded.
We will give you the liberty to make a mention if they take
Yes.
The shall be at liberty to make a fresh application seeking interim relief if any coercive step is taken anywhere.
Obliged.
My lord, essentially, there are
Our elders used to say that it is easy to defend a case than to make it out.
My lord, I have forgotten what I was doing some time back. My lord, the prayer essentially is, I am challenging the virus of section, if your lordships kindly turns to page 68, my lords.
Page?
68.
Sorry. Just a minute. Item 2. Sure.
Lord, page 68 is the prayer.
68 is the prayer.
My lord. He is the culprit. When briefs come from Delhi, they are big. I know. So, my lord, if your lordships are pleased to see 68 minutes, page 68.
Yes.
So, my lord, one prayer is for declaring the proviso to section 4A4 and rule 20 sub-rule 6 as unconstitutional. And I'll tell your lordships why. My lord, there are two other orders which have been passed pursuant to these provisions that your lordships will get at page 70. One is 23rd of August 23, Roman 5. And the other, my lord,
16.
and the other is, my lord, 16th of July 2024. The first order is at page 267 and the second order is at page 359. Well, I'll give your lordships a small list of dates. Your lordship will not worry about that. My lord, shortly put, mirrors. If your lordship looks at these two provisions. Your lordship may be pleased to see, my lord, section 4 of the MMDR.
Yes.
My lord, 4 says, no person shall undertake any reconnaissance, prospecting or mining operations. We are concerned with mining operations in any area except under and in accordance with the terms and conditions of a reconnaissance permit, prospecting lease or the mining lease granted under these act and the rules made there. So there is an embargo that unless you have a mining lease, you cannot carry on mining operations, and that mining lease must provide for the terms and conditions. Well, am I clear? May I read it again?
Yes.
No person shall undertake, my lord, I will skip reconnaissance and prospecting, mining operations in any area except under and in accordance with the terms and conditions of a mining lease granted under this act and the rules made thereunder.
No, but the first relief which you are seeking.
Yes, my lord.
Confusing.
Yes.
For the reason that you are saying that this section should be held ultra virus.
Not this one.
No, any provision.
Yes.
Any provision
I'm
of
grateful.
the act.
I'm grateful.
You are saying that this should be held ultra virus read with rule.
Yes. And why, my lords?
See, either the section is maybe ultra virus,
yes.
or the rule may be ultra
Correct.
virus.
So
But section is ultra virus read with rules.
and what I'm saying is, I'm grateful. I may be wrong there. I'm saying proviso is ultra virus. So also rule 26.
That is different. That
Yeah, and I'm so sorry.
it is ultra. This gives an impression that you are saying.
My apologies. Beloved, I stand corrected. I stand corrected. Now, therefore, 4 says you will only carry on mining operations if you have a lease deed and in terms and conditions of the lease deed. Right. Now, my lords may kindly turn to section 4A4. We are here concerned as to whether in the absence of a duly executed mining lease, there can be a lapsing. That's the point. So if my lords kindly sees 4A4, my lords have it.
Yes.
Subsection 4 of section 4, 4A. 4A, I'm grateful, 4A. Where the holder of a mining lease, kindly note, my lord, it also says that where the holder of a mining lease fails to undertake production and dispatch for a period of 2 years from the date of execution of the lease, or have commenced production and dispatch, continued the same for 2 years, the lease shall lapse on the expiry of the period of 2 years. So what it says is that if you have a lease and you fail to work for a period of 2 years, or discontinue at a subsequent time for a period of 2 years, the lease shall lapse. But the precondition is very clear that there must be a duly executed lease. And that is because of section 4, which says you can only work if you have a mining lease. Now, if your lordship sees the proviso now, which is in the part is, provided that the state government may, on an application made by the holder of lease, before it lapses, on being satisfied that it shall not be possible for the holder of the lease to undertake production and dispatch or continue such production and dispatch for reasons beyond its control, make an application within the period of 3 months from the date of receipt of such application to extend the period of 2 years by a further period not exceeding 1 year, and such extension shall not be granted for more than once during the entire period of the lease. So you leaseholder, you have failed to work for 2 years. I will only extend it by 1 year and nothing more. Now kindly see the second proviso. Provided further that such lease shall lapse on failure to undertake production and dispatch, commence production and dispatch, fails to continue the same before the end of the extended period. So therefore, 2 years time is granted. If you do not do it, then, my lords, it will come to an end by way of automatic lapse. The question before your lordship is, my lords, whether vested rights can be taken away by a automatic lapsing. Namely, it will lapse after 1. Now, my lord, this question fell for consideration of the Honorable Supreme Court in the case of common cause. Where is my judgment? If my lords are kindly pleased, Millets, to turn to paragraph 32 at page 63, my friend. My lord, identical question came up for consideration before the Honorable Supreme Court. And that, my lords, will be pleased to see at para 32. Your lordships have para 32.
Yeah.
That is at page 63. Having addressed the issue with reference to subsistence of a mining lease on the basis of an interpretation of section 8.8a, we have substantially covered the area we needed to be transferred. It is, however, important to notice one further aspect, needs to be dealt with. The same emerges, my lordships, I would.
Yes, please.
The same emerges from a collective reading of 4A4 read with the rules 28 and 29A of the MMDR Act. My lord, what they do is they quote section 33, and let me read thereafter. A perusal of the aforesaid provision reveals that where a mining leaseholder does not carry out mining operations for a period of 2 years, his mining lease would lapse. It was the contention of the learned counsel for the petitioner, common cause, as also the learned additional solicitor general, that the operation of section 4A4 is automatic and requires no orders to be passed. It was submitted that as soon as the leaseholder has committed the default of not being in a position to carry on or not having actually carried on mining operation for a continuous period of 2 years, the lease would lapse. The above two exigencies will be referred to as the first and second contingency respectively. Para 34. To council, the only remedy available to such a leaseholder to prevent the lease from lapsing is to move an application either prior to the expiry of the period of 2 years or thereafter. The state government, on being satisfied that the mining operations were not discontinued or expressed above reasons beyond the control, could make an order in the first contingency and the lease would not lapse. In the second contingency, the lease would remain. Now kindly see 35. It is not possible for us to accept that vital vested rights in a leaseholder can be curtailed without affording him an opportunity to repudiate the impressions of the competent authority, namely the leaseholder could not have or actually not carried mining operations for a continuous period of 2 years. So therefore, Miller, saying, our instant contemplation, etc., etc. So what they say is, there is no concept of auto-lapsing. You have to give a notice. Hear the other side, why he is not able to carry, and if there are good grounds and he can repudiate it, then there is a relief, and it is not auto-lapse. Broadly, this is what I am trying to submit. In my case, Millers, I don't have a subsisting lease.
Yes.
My lord, in the present case, if your lordship sees the list of dates which I have given to your lordships. My lord, a lease was granted in my favor on the 1st of August 1998, and the lease was to expire on 31/7/2018. Your lordships have that in it. The very first date.
First day, 1/8/98.
1/8/98, I was given a lease for 20 years, and that was to expire on 31/7/2018. Now, my lord, the next date is on 1st of April 21. My mining operations were suspended by the Director of Mines, deputy for want of environmental clearance. If your lordships looks at the third date, my lords, I filed an application under 28(1). That was rejected. If your lordship sees now, page 3, and this is a little important, lords. On 12th of January 2015, the MMDR Act was amended. And what it says is, if you were granted a lease prior to 12/1/2015, it shall be deemed to have been extended for 50 years. That I have quoted, my lord. What it says is, all mining leases granted before the commencement of the MMDR Act shall be deemed to have been granted for 50 years. The reason is, they said now every lessee will get a 50-year lease.
Yes.
Now, my lord, if your lordship sees the next date, 17th of August 2015, the state government passed an order after the amendment, declaring that your lease has lapsed. My original lease, which was to remain valid up to 31/7/2018, that was lapsed.
Which date?
My lord, my original, your lordship saw in the first page, the lease was to expire on 31/7/2018. The very first number, my lord. Lease was granted on 1st of August.
Yes.
98, 20 years. That takes it to 31/7/2018.
Yeah.
Now, in the meantime, by operation of 8A3, and extended for a period beyond that, 350 years. So, my lord, they pass an order. State government passes an order on 17th of August saying your lease has lapsed under the old auto lapsing principle. Serial number 5. If your lordship now sees serial number 6, my lords, I file a revision challenging the said order. Now kindly see serial number 7. On 11th of May 2016, my lord, by this time, the common cause judgment has come. So what the revisional authority says is, the revisional authority by common order in revision case number so-and-so set aside the order of lapsing dated so-and-so and remanded back to the state government for suitable reconsideration in line of the apex court judgment in common cause, negating the concept of auto lapsing. Notwithstanding the perceived understanding, so they quote the Supreme Court judgment, notwithstanding the perceived understanding on lapsing provisions, with the apex court judgment on the issue, there is clarity on the lapsing framework and related process in accordance with the apex court direction. Now it is clear, supposing that lapsing is not automatic, and the provisions and cause for discontinuance of mining operation. Kindly see, below. Provision and cause for discontinuance of the mining operation has to be preceded by scrutiny and steps fulfilling the maximum of natural justice. In view of the above, the impugned orders listed so-and-so needs reconsideration to follow the directions provided in the apex court judgment. Therefore, all the impugned orders are set aside. So that lapsing order, my lord, is set aside. And my name is there at serial number 31, my lord, so I will not trouble your lordship. Now, on 8th of March 2017, the state gives me a show cause. So this is post the common cause judgment, post the revisional order. My lord, am I clear, my lords? And then on 31/7/28, my mining lease of 1898 expired. Because that is your lordships have seen on the very first serial number. Now, my lord, under sub-rule 6 of 20 of the Minerals Hydrocarbon Rules 2016, the state government shall, after examining the adequacy and genuineness of the reasons of non-commencement of production and dispatch or discontinuance of pass an order within a period of 3 months from the date of receipt of the application made under sub-rule 3. So this is also under challenge, or the date on which the mining lease would have otherwise expired, whichever is earlier, either extending the period of 2 years by a further period not exceeding 1 year, provided that, not this proviso is the problem, provided that such mining lease shall lapse on the failure to undertake production and dispatch or inability to continue and dispatch within the extended period, provided further, such extension shall not be granted more than once. Now, my lord, on 18th of January 2022, a forest diversion proposal for mining was put on the portal, and the same is pending consideration of the state government. Why this is important is, I need a forest clearance for executing a mining lease deed. Lord, on 3rd of November 2022, the State Environmental Impact Assessment Authority issued terms of reference for public hearing. My lords may kindly turn over the page, lords. And now come to serial number 13. My lord, after remand, the state government passes an order in my favor. Would your lordships kindly be pleased to have a look at that order? 271. It starts at 267. And it sets aside the lapsing. That is annexure 19, 23rd of August 2023, page 267. And my lords may kindly be pleased to come to page 269, where the findings of the are recorded. My lord, the Chief Justice has page 269.
Yes.
Since the revisionist, well, this is the last paragraph. And whereas brief inquiry of the case is as following, my lordships have that.
Just
at the bottom of the page, minutes.
Just.
I'm sorry.
This is which annexure?
My lord, this is annexure 19. It starts at page 267 and the relevant page is 269.
Yes.
So bottom of the page, my lord, these are his findings. And whereas the brief inquiry of the case is as following. My lords have it.
Yes.
Since the revisionist, that is me, indicated that he has deposited the demanded compensation amount in pursuing the statutory clearances, kindly note, my lord, and is pursuing the statutory clearances with due diligence. I am heavily relying on this. Matter was taken up for verification through the Director of Mines, Mining and Geology. As intimated by the Directorate, the revisionist has deposited the compensation applicable interest on so and has also deposited an amount of so for the undisposed stock. Since there is no production beyond so, no further compensation is demanded. It has also been indicated that in the report that the revisionist is in possession of a mining plan along with the MPCP valid up to 2027. Mining plan is one of the documents I require to execute a mining lease. So he says they have it till 2027 and is pursuing with, kindly note, my lord, and is pursuing with the statutory authority for the EC and FC and CTO. So I have a mining plan. I am pursuing it diligently for EC, FC and CTO. And then, my lord, and whereas the observations of the authorized officer conducting the hearing as follows. The lease was granted on so for 20 years by operation of the amended statute 886 and as per the provisions of the lease is eligible to be considered valid till 7/20/48. Kindly underline this. So my lease is valid till 7 that is July 2024. If not decided otherwise and subject to the condition that all the terms and conditions of the lease are duly complied, due opportunity of hearing has been afforded and the orders of the Honorable Apex Court and orders of the Revisional Authority in the instant remanded case, the Honorable Supreme Court have prescribed certain principles for deciding the case of leases in their judgment. Your Lordship may skip all that, my lords. Then he refers to para 30 and 32, which your Lordships have already seen. If my lords kindly turns over the page.
Yes.
271, second paragraph. And whereas in the instant case, the mining operation of the lessee was stopped owing to the fact that it didn't have statutory clearances except mining plan and was declared lapse on completion of 2 years, although orders were passed in 2015. Besides, forest clearance is mandatory in this case to next turned out to be classified as forest land. Your Lordships have it?
Yes.
So, for so saying, my lords, kindly see, my lords, the last but one paragraph, or the last paragraph, lords. Last but one paragraph. And whereas the authorized officer has recommended that the instant mining lease is subsisting in conformity with the amended provisions of so, stipulations and observations of the Supreme Court, by orders dated so and so, to hold that the lessee is entitled to get the benefit of the above order. Since the lessee is not under obligation to pay any government dues and also diligently pursuing the statutory clearances, it may be considered that the lessee may not have been declared to have lapsed under Rule 26 of the so, subject to the condition that the lessee shall commence production and dispatch within 1 year. Now, this is the offending part. Within 1 year of issue of this order, on production of the statutory clearances, the lessee will be allowed to execute supplementary lease deed for the balance period. So he's saying two things. One, my lord, that you are diligently pursuing, you get the statutory, we will execute a lease deed for the balance period. Lord, am I clear, my lords? Now kindly see, now therefore in view of the above, after careful consideration, have been pleased to order that lapsing of mining lease over an area of so in the district of declared not to have been lapsed under 26 of the mineral concession rules, subject to the condition that the lessee shall commence production and dispatch within 1 year of issue of this order on production of the statutory clearance. My difficulty is this, because I can only apply. It is for the other side to give me the clearances, namely the state and the center. And it is the finding of the state government that I am diligently pursuing, my lords. I can't do anything beyond that. And I'll show you, lordships, why it is getting delayed. And the other order which I am challenging is, lordships will say at page 359, annexure 38. My lords have page 359.
Yes.
Kindly see, my lord, regarding request for extension of time up to 31st of December 2025 for submission of the statutory clearances for execution of the lease deed for the balance period and commencement of production and dispatch as per the order dated so and so in respect of so and so. So what we did, my lords, we made a representation at page 352 saying that we are diligently pursuing all this. Kindly grant us time till end of 2025 to get all the statutory clearances.
Yes.
Now, what he says is, with reference to the above correspondence on the subject cited above, I am directed to inform you that proviso of Rule 20 sub Rule 6 does not empower the authority to grant any further extension of time and prescribes that the mining lease shall lapse on the failure of the lease to undertake production and dispatch or inability to continue production and dispatch within the initially extended period. In that view, the request of extension is regulated. My lord, my submissions are threefold. First, my lord,
yes,
the impugned orders are without jurisdiction for the reason there is a categorical finding, and rightly so, in the first order which I read to your lordships, that a fresh lease is only to be executed after I get all the clearances. That is at page 271. Now, section 4 says, 4A4 says, that you will only carry on mining operations after you have a duly executed lease deed. Am I clear, minutes? If you do not work for 2 years after you have had a duly executed lease deed, you will be penalized. Not in my case, at page 271, the state is saying that you are diligently pursuing your statutory clearances. Once you have it, will execute the lease deed, and thereafter you have to commence mining operations. Now, I am stuck between the various departments of the state government, in as much as, my lords, if your lordships are pleased to see, page 276, I keep on writing to them. But if your lordship sees 274 minutes, I'm sorry. Just to give you lordship's minutes. My lord, for these cases, there has to be a public hearing. And if your lordship sees page 274, and the date is 7th of December 2023.
Yes.
My lordships have it. Now, here the Pollution Control Board is writing to the collector. Hearing proposed FACOR at so and so, public hearing. So there's a public hearing which is necessary. So what he is writing at the foot of the page, my lords. Further, it is reiterated, lordships have it. Further, it is reiterated that the conduct of public hearing is a time-bound program. Public hearing is to be notified through newspapers, giving at least 30 days notice. I would request you to suggest a date, time, and venue at least 40 days in advance for conducting the public hearing. Right, my lords? My lords may now kindly see the next step. Kindly see, my lords, page 280. And kindly see the date, 16th of March 2024. My lords have it, 280. Now here the collector is fixing a date of public hearing. If your lordship looks at that table, my lords,
yes,
lordships have it. He fixes it to 26/6/24. 26/6/24, 11 a.m. My lords may now kindly see the next page. Now the State Pollution Control Board is issuing a notice that there will be a public hearing. It is brought to the notice of all concerned that FECOR for so-and-so has proposed to have a EC for production of so-and-so. And if your lordship sees the last paragraph, my lords, persons desirous of participating in the public hearing may go to the EIA notification, EMP, and the said project will be available so-and-so. So therefore, they are saying you come and participate. Now kindly see, my lords, page 285. My lords have 285 minutes.
Yes.
Now the collector is postponing the hearing. Postponed a public hearing proposed by now at 286, the Pollution Control Board is now saying that please refix another date. If your lordships have seen that. Now, my lord, I am now told that the public hearing is now fixed. Is now fixed to 16th of August 2024. Now, the latest notice which we have received, it says the public hearing will be conducted on 16th of August 2024 by the collector. Hopefully, it will happen on that day. So, my submission is twofold. A, my lords, that lapsing would only happen where there is a duly executed mining lease deed. Admittedly, my lease deed is pending because the clearances are not there. Although my lease has been extended and granted by operation of 8A3, but there has to be a document. Now, for that document, I'm running from pillar 2. And now, therefore, my lords, the submission is this. A, till you have a lease deed, 4A4 doesn't apply. Therefore, this is without jurisdiction. And second, my lords, that I can't be held responsible for the inaction. And therefore, the Honorable Supreme Court says, give him an opportunity to get the claim. And I would tell them that, look, you yourself are not conducting a public hearing. How do you expect me to get a clearance? So your lordship may read down 20A6, your lordship may read down 4A4 proviso to say, in sync with the Honorable Supreme Court's judgment in common case, that look, if the party is prevented from getting a clearance for delay on the part of the state government, that should be a relevant criteria.
Please come to 37.7 of the judgment.
Yes, madam.
And someone is appearing for the Pollution Control Board.
Different counsel, your lordship.
Yes.
My lord, may I read this? Based on the interpretation placed by section so and so, we draw the following conclusions. Firstly, under an order is passed by the state government declaring mining lease as lapsed, mining lease would be deemed to be subsisting up to the date of period provided by the lease document. My my lease document is over. Secondly, in situations where an application has been filed by the leaseholder, when he is not in a position to, or actually not for carrying out mining operations for a continuous period of 2 years, the lease period will not be deemed to have been lapsed till an order is passed by the state government on such application. Where no order has been passed, the lease shall be deemed to have been extended beyond the original period of lease for the further period of 2 years. Thirdly, a leaseholder has suffered a lapse in this entitlement. So what it is saying is,
it says that an order must be passed.
I'm grateful.
And in the absence of any order, there shall not be
automatic I'm grateful.
Cessation.
Yes. So therefore, if your lordship says 359, it is now saying that it shall lapse without any order. because that is how they 26. My prayers are threefold. Your Lordship may issue notice. Let them file counter. In the meantime, at least, my Lord, the authority should process my applications for grant of permission. For example, this is now posted to 16th of August. They should not say, no, notice has been issued, we will not proceed with. And in the past, my lords, where there were challenges to other provisions of the Act, give me the dossier, Lord.
Yes. Say something. This is questions. This is also this. Yes, sir.
This honorable court, by way of interim order, my lords, had said, may I slowly read it, my lords? Paragraph 5, as such, we allow this application, direct the opposite parties to consider the application of the petitioners for grant of foreign clearance under section so and so, expeditiously, in accordance with the law, and the same be kept in a sealed cover to be opened as per the direction of this court in the writ petition. That is at page 3, paragraph 5.
Yes.
This hearing, which they have now fixed to the 16th of August.
And what is the date when your
My Lord, he says that this will come to an end on 22nd of August. Is that 22nd of August. Because the 23rd August, not from 23rd of August, it is 1 year. Now, if on 16/8 he holds a hearing, obviously nothing is going to happen by that date.
Why?
Because this hearing will happen. Stage 1 clearance will be given by the state. It will go to the government. And my Lord, your Lordships will see, my Lords, I have annexed a document that in one of the common cause cases, the Honorable Supreme Court wanted to know that the FC clearance takes how long. And if my Lords kindly see.
No, in fact, what I propose to
I am
do.
grateful.
In fact, we need to lay down a guideline.
I'm grateful.
In such cases.
I'm grateful.
Like these litigations should not come to.
I'm grateful.
If it is the Pollution Control Board which has to take a decision, or the authorities they have to take a decision, then they should take a time frame.
Time in sync with the other provisions of the Act.
In sync with, and depending on the date also, when suppose in a particular case,
yes,
the term is going to lapse on a particular date.
Correct.
Then the authorities will have to keep that in mind.
Grateful.
That a decision this way or that way must be taken, unless
I'm grateful.
Otherwise these
My
are
Lord, what will happen is
these
my
are
Lord, what fell from your Lordships will prevent a large number of litigations being unnecessarily coming.
exactly. So what we intend to do
My Lord.
is that we will post this matter on 20th of August.
My Lord.
Just to
See, my Lord, what has happened there?
see what has happened.
I'm grateful.
If there is any standing counsel for the pollution
We will
control,
serve them.
please serve upon
And
them.
my Lord, the state also should find out from the collector whether they're doing it on that date or not. Your Lordships have seen collectors adjourned it twice.
So 20th we are listing, and on 20th we will decide how to deal such matters. So this is a case.
This is only illustrative. There will be so many matters.
We
like
can
this.
we can lay down a guideline.
Grateful.
And if we on 20th we will pass any interim order if
Fair enough.
required.
Lordship.
We will take up on priority basis.
My Lord.
What do you want? You are right. You should convey through him only.
What he's saying is that let it come at 2 p.m.
No. Within first 5 cases.
My Lord.
We will take up at
Your
10:30.
Lordship.
See, there is no difference between 10:30 and 2. It is not that we don't hear patiently 10:30 matter.
No, my lord. That is the last thing that somebody can say.
We are not doing.
It is.
But I was only
we-
requesting, if your lordship should pass an order that they will come back to your lordship saying what has happened on this next. And the union can file their counter on the challenge to the leases or on.
No, whereas we are not, we will take up later,
Fair
if
enough.
required.
Fair enough. Fair enough.
If we are not required to go into that aspect, then why should we
Fair enough.
go into that presently?
My lord.
Issue notice. Learned AGA accepts notice on behalf of. Let's copy 2 copies of the writ application be served upon learned counsel who generally represents Pollution Control Board. The Union of India is a party.
Yes, madam.
Copy, someone is appearing for the Union of India.
My lord, we will serve it in the AG's office.
Yes, my lord, a copy has been served.
Mr. So accepts notice on behalf of. Stop. List this matter 28/2024. When the when the collector, no, when the state shall be required to inform this court as regards the development in which is there any case number or something?
Well, if that lordship sees, my lord, that 16th of August, that next date.
Filed by way of memo.
I have just filed by way of memo. But it is. Yeah, Madhya. It says 16th August at 11 AM.
A development as regards the public hearing fixed on 16/8/2024 proposed by the petitioner.
By the pollution control.
No.
So they are writing to the promoter in respect of the petitioner's forest land.
Say the subject is proposed by.
Yes.
So you propose that there should be a public hearing, is it?
The state control test tells the collector that you hold a hearing.
But why?
Yes.
Regarding MS Fero Alloys Corporation Limited bracketed the petitioner for Katasi manganese ore mines. Katasahi manganese ore mines as communicated wide letter number 1964 163 dated 29/7/2024 addressed to the member State Pollution Control Board. A copy of which has been furnished to this court through a memo on behalf of the petitioner. Is this case on 20 million? We need first 5 cases.
Grateful.
Let the This said memo is taken on record. First of however, and counsel for the petitioner shall be required to file the same by way of affidavit.
I'm grateful.
In registry.
I'm grateful. Deeply obliged.
Item number 22.
Your Lordship. Petitioner for Lordship is the secretary of a non-governmental organization, Lords, having vast experience in implementing the healthcare program in the state of Orissa, funded by the state government and Millards government of India.
What do you want?
Because here, Millards, I have challenged the condition, the restriction imposed in the tender paper, Millards, on the ground, Millards, because it is a state and bond is usually.
What do you want?
Plus, I want to quash the said condition, Your Lordship, because it is affecting me in view of this page 21, Your Lordship, the condition 3.3.1, my lords. In the state, a maximum number of 10 projects only, which can be sanctioned to a particular agency out of ONCH and FWS funds, and in a district, maximum up to 5 partners under so
you want to do more and more projects?
Plus, I am already working, my lords. I have experience because Your Lordship can glance to the page 20, my lords, column 4, my lords. Page 20, my lords, the eligibility criteria, Your Lordship. The bidder must have experience implementing program in healthcare with funding support from government or donor agencies in any 3 years in the last 5 years, last 5 financial years, 19, 20, 21, 22, 23, 24 years. I'm working, Millers. I have the experience, Your Lordship.
So how is this a public interest?
Plus, not public interest, Millers.
Yeah,
I am the party, Millers. I am the secretary of the organization.
It is not a PIL.
No, Millers.
All right.
Millers. You will find, Millers, in the last.
Why you telling that for us? Tender.
Millers. Tender, Millers. Tender.
Where is that?
Because you not mention anything in your prayer, the tender, work order, anything.
I'm sorry, Millers. Tender, Millers.
Where is the condition?
Millers, condition is, Millers, page 21, Millers. Page 21, Millers. $3.3.1 Millers. 3.3, the maximum ceiling limit of projects under Orissa State Health and Family Welfare Agency in the state maximum under 10 projects, including ongoing and new, which can be sanctioned to a particular agency out of so and so. And the next is, Millers, in the district maximum up to 5 partnership projects, including ongoing and new, under so and so funds can be sanctioned to a particular agency, Millers.
Which clause? Which clause?
Section 3.3.1, Your Lordship. Page 21, Millers.
Yes. Which part?
3.3.1, Millers.
Yeah, 3.3.1 we are seeing.
This is the condition imposed, Millers.
So you are challenging this?
Yes, Your Lordship. On the ground, Millers, Your Lordship can glance to the last notification, the last tender, Millers, because this finance is provided by the government of India to the states, Millers. Government of India has not imposed any restrictions.
What is there in 3.1? 3.3.1. Oh, just a minute. Just a minute. What is wrong in it?
Plus, because by this way, plus, Your Lordship can glance to the condition 4, Millers. The eligibility criteria, the page 20.
No, the state wants that others should also have the opportunities. How can you have
yes,
monopoly?
why, Millers? Why I am before Lordship, Millers?
Yes.
Because in the last occasion while Millers tender was floated, Millers, Lordship can glance page 83, Millers. There was no such condition, Millers.
So?
And Millers, in respect
So there cannot be any such
because I have experience, Millers. I am working in
You
this
may
field.
be having experience, but everything should not be given to you. See, you are so competent that you can run the estate.
Yes.
Therefore, the functioning of the estate should be handed over to you. This is your assessment by about yourself.
Millers, my summary is not before Lordship that, Millers. So far as the other states are concerned, Millers, Your Lordship can glance to the notification issued by the Gujarat, Bombay, plus Rajasthan and other states, no such condition is there, Your Lordship.
All right.
Because fund is provided by the government of India. Government of India has not put any restriction like the state of Odisha, Your Lordship.
All right. We don't find any irration.
By this way, I will be restricted. My tender paper will not be considered, Millers.
Should not be
Although
considered.
I am eligible, otherwise I am
Yeah,
eligible.
you may be eligible, but you should confine yourself to 10.
Plus, working earlier, Your Lordship, not in this project, Millers. I am working earlier in other projects of the government of Odisha, Millers.
What is the meaning of NGO?
Non-government organization, Millers.
What for these NGOs are established?
Were established, Millers.
What for these NGOs are formed?
Working, Millers, plus, in public health sector, Millers.
Public health sector for what?
Like
for earning?
Millers?
For earning?
No, Millers.
Then?
Providing, Millers, service, Millers.
Providing service?
Millers.
Without?
With the aid and advice of the government, Millers, because government of India is providing funds, Millers.
Yes.
We're implementing the guidelines of
No
the government.
profit. NGO is for profit.
No profit, Millers.
Then why are you so worried?
Worried because I am getting restricted because of this
Yes, you
condition,
should be
Millers.
restricted. You should be happy that you should confine yourself to 10.
Not this case, Millers. I am working in other projects, Millers, not this project, Your Lordship.
Yes.
And earlier I have already worked in this project, Millers.
Maybe, may have been working. This is a very reasonable clause.
But it has not been put in other by the other states, Your Lordship.
So
Because
these-
finance is provided by the government of India, Millers. Government of India has no restriction. Other states, they don't have such a restriction.
So Odisha should follow other states.
That is not my
Why?
submission.
Other state may follow this stipulation.
So I have submitted my tender, but this will not be considered, Millers, because
Should
in
not
this-
be considered, Mr. Counsel. The Indian Management Technical Society claims to be a non-government organization. Where is your not certificate, your objects?
Yes, bylaw I have not annexed, Your Lordship.
You have not annexed.
No.
You will never annex.
But I filed the experience
Where have
certificate.
you mentioned?
Plus
Where
what-
have you mentioned? What are you?
Plus para 8 Millers. Page 4.
Mentioned having experience of implementing programs in healthcare with funding support from the government and donor agencies. So it also claims it has received several awards from the government of India for its outstanding work in the field of elimination of TB. So stop. In the present writ application filed under Article 226 of the Constitution, the petitioner has put to challenge clause 3.3.1 of
Plus tender notice dated 3/7/24.
of the request for proposal. If the Directorate of Public Health Odisha which is the Odisha for selection of patient provider support agency bracketed PPSA under National TB Eradication Program. Reads as under 3.3.1 on court 3.3.1 in the estate, comma, a maximum number of 10 projects only bracketed includes ongoing and new, which can be sanctioned to a particular agency out of what is OSH?
So Orissa State Health and
Orissa-
Family Welfare Service.
OSH and FWS funds. Stop. Learned counsel appearing on behalf of the petitioner has argued that the said scheme is centrally funded and the central scheme does not stipulate a restriction of the number of projects as stipulated under clause 3.3.1. He submits that keeping in view the vast experience of the petitioner, comma, an NGO, comma, such stipulation restricts the opportunity of petitioner to participate in the tender process. So stop. Next. He submits that the said clause is arbitrary, as also unreasonable. So stop. We are not convinced with the submissions advanced on behalf of the petitioner for two reasons. So stop. Firstly, the said criteria, more than one reason. Firstly, this apparently applies equally to every participant in the process of selection, be it a company, comma, NGO, or trust. So stop. Secondly, comma, the petitioner does not claim to be a profit-oriented NGO. So stop. Thirdly, comma, the comma, such stipulation is apparently aimed to obviate a situation where a company or an NGO acquires monopoly in execution of such the project of their projects, execution of the projects funded by so and so, क्या है वो? Family welfare, health service. What is that? Health service. Funded by, this is funded by OSH, Orissa State Health and Family Welfare. OSH and so, in the court's opinion, this application is misconceived and is accordingly dismissed.
Item number 24.
24, my lord. This is a writ application in nature of PIL, my lord. The sole grievance of the petitioner here, my lord, to protect the valuable human life and to the road safety in the district of Jharsuguda, because in the last 3 months, 61% has been died in the meantime, my lord. So because the entire traffic flow has been failure there, the district administration has not taken proper steps for free flow of the traffic, my lord. Please, my lord, in the year 2001, my lord, the state government has instituted a road safety council headed by.
File affidavit.
I'll file it.
A good cause which has been taken up.
Obligation.
Let counter affidavit be filed on behalf of the state within 6 weeks. Issue notice, 6 plus 8 weeks. List.
Item 25.
Moment, the petitioner prays for revaluation of OMR answer sheet of the revaluation of the OMR answer sheet of
That
the,
cannot be done.
my lord, on comparison from the answer key and the sample answer key by the annexure 6 published by NEET, there is 4 mark difference. The petitioners secured 639, but it should be 642.
Which is this? Which examination?
My lord, NEET UG 2024. My lord, answer key. My lord, the petitioner's answer sheet is annexure 4. And the answer key published by NEET is annexure 6 at page 53.
How many answers you have been given, ma'am?
My lord, in respect of, I have compared all questions with the answer key. I found in all the I think in chemistry, botany, and zoology, answer is correct. But in case of physics, I have answered questions 4 4 questions are wrong. 10, 20, 21, 25, 36 are wrong. And 29 and 34 are not. So my marks should be 142 minimum. But one thing happened, I have marked question number 39, 2 answers. That may be incorrect.
Right.
Leaving that, my score should be
You cannot leave that.
No, my leaving that.
You cannot leave that.
No, my lord, I am not considering that one.
No, you cannot.
No.
You will have to consider
My
in
lord,
terms of negative.
even in that case, if it will be considered, then my score will be 147.
Have you taken into account the negative marks for?
Negative marks. My lord, last time I have also made mail to NEET authority.
Yes. For the need.
They made a reply that it will be taken up, but till date it was not taken.
Where is the reply?
My lord.
Not part of the writ petition.
No, recently.
But you filed this.
Yes, who is for the Union of India?
Your Lordship, I am appearing for Union of India, Your Lordship. Open to for Your Lordship along with non-DSJ, Your Lordship. In the meantime, I will take instruction, Your Lordship.
How do you want?
How many days?
Take instruction. 2 weeks, Your Lordship.
Tomorrow. Tell her.
2 weeks, Your Lordship.
We will take up the matter tomorrow again.
Examination matter, copy has been served on you. It will be taken up tomorrow.
Seek instructions.
Your Lordship, obligation.
Considering the urgency of the matter, which is admission to which course?
NEET UG, NEET undergraduate 2024.
Exam.
To NEET 2024, list this matter tomorrow to be taken up at 2 p.m. for learned. Your
CGC.
Sulojana Patra, CGC along with non-DSJ, Your Lordship.
No, Sulojana Patra. Sulojana Patra and CGC.
seek instructions.
You serve a copy of this on her also.
You have not served. Sir.
This you have served?
No, that.
Serve it today immediately.
Please do it. Please contact them. Please contact them technically. Tell them that the matter is very urgent. If required, we shall direct them to file an affidavit, but there is no such direction required in this case. So they should examine, they should say.
You file this along with the memo today so that it can come on record. Slip to the record.
Item number 60.
My lord, item number 60, there are 23 cases, and item number 18, there are also near about 18 cases. The case of this, the matter of this case is the main road. After verification of the deficiencies and all that, they were supposed to get inspections. So the inspection date was communicated to them to be done on online, but they have denied online. On the most of the cases, there was election and there was some staffs are not available. I, my lord, wanted to get instructions from the department why you had fixed dates for those institutions. So they have decided and give me an instruction that only those cases where on election day or prior to 2 days, before 2 days, the inspection date was fixed. They will reschedule them for that consideration. With that observation, all the letters.
You think 2 days before and 2 days after?
Yes, my lord, that's what.
Indicate one. In respect to a one-friend. Sorry, next time, persons were employed. Some are from Purapur, they are employed in Cuttack. Some are in Nagarpur, employed in Bhubaneswar, from Nagar. It takes at least 2-3 days time to travel and to attend the election duty. And election duty also takes 2-3 days. So we give respect to my friend's submission and I beg your assist. It's not 2 days, confined to 2 days. Must be a relaxability. 4-5 days will be the better because the traveling and the duty the person who are doing, they have to submit the ballot paper at a place after the election is over. So they are-
See, if you want the court to examine, the court will examine on case to case basis. Like, see, 60 first case. This is Koraput. All right. So you are appearing in this case.
No, Yes, I agree.
You are appearing in that case. So you give us the date when the election was scheduled. 13th, all right.
13th was the date on which the inspection was done.
All right. So your case is different. Your case may be different. All right. Now let us move to the next case. Ekmara, who is appearing in Ekmara school?
You probably have a case where you want some more days are involved. You probably have a case. That is why you're mentioning.
No.
Instead of the same date.
Do you have another case?
Yes, I've got, sir, 1685, 2024.
1659,
2024.
1685.
Four items after.
16585.
And 16589.
16585. So this is also Koraput. All right. Same date, 13th. Then come to Sailbala Institute. Where is this? Same. So far your case is concerned, they are taking care of. Now, which other so see, this is the concession. This is the concession which the DA is going to give. All right. So if you accept that, it's all right. If you don't, then we will go deep into the matter. You want? Accept.
And Mr. Another thing, are any of them supposed to go for election duty?
In my case.
Your case is considered. Your case is considered. And London Friends institution is covered. We are accepting that.
All of them are covered.
Yes, my lord. Yes, my. 2 days before, 2 days after, and on the date also election, the 5 days total. All the cases can be disposed of with this.
My lord, item number 18.
Just a minute. Before, let us complete this. 60. 60 all relate to new NOC.
My lord, new and old, both are there. Both are there. So renewal be.
These
All
are renewal.
Yes.
18 also?
18 or 60?
18 also? You said that.
18, 7. 18. 18 few cases. Not all. All 18 matters
Yes,
are covered.
Yes, yes.
18 one matter is my lord.
Except All 18 matters.
Yes, my lord.
Except this one.
Item 60.
23,
18 matters, 60.
in 60, 18 matters.
Uh,
9, 10, 11. 10, 11, 12, 9.
All
So
these
23. How about that? 40
cases relate to grant renewal of NOC by DMET to institutions conducting nursing courses.
Different courses. ANM, GNM, PhD.
Different nursing courses.
GNM and PhD.
Nursing courses.
ANM, GNM, and
BSc and MSc.
BSc and M.
Post-basic nursing courses.
Nursing courses.
And
Also, only my lord, nursing courses will define everything.
It will cover.
Nursing courses.
In bracket, nursing courses. Stop. It is an admitted position that for grant of renewal of NOC and online inspection
Yes.
of the colleges, online inspections of these institutions were required to be conducted by the DMET.
Yes.
no, it's both for granting and renewal also.
No, first of all, inspection for granting NOC,
Whether these matters relate to grant or only renewal.
only renewal of, only grant of NOC, my lord. Grant of NOC.
Grant or renewal.
Inspection is required for first time also, for renewal also.
Yes, my lord.
So these involve first time
Renewal,
So not first time.
not first time.
First time the NOC has been granted by the committee, thereafter.
All right.
Renewal.
Stop. It is the grievance of these petitioners in the present batch of writ applications that because of general/assembly elections in the state, the institutions could not make themselves available for inspections online.
Yes.
On the dates fixed by the DMET.
And all of you had requested for deferment of the date.
Yes, my lord.
All.
Yes.
Stop.
I have got the instruction one para.
Instruction.
It is the petitioner's case that it is the case of the petitioners that they had made requests to the DMET for rescheduling the time for online inspection, date for online inspection. It is in the same background that these applications have been filed seeking direction to the DMET to conduct inspection.
Yes.
Online inspection on
Fresh date. Fixing a fresh date.
fixing fresh dates. Stop. Next, Mr. Counsel and Counsel for the DMET, Mr. Simonti, and Counsel for the DMET has stated that he has received following instructions to be conveyed to this court. colon dash for conditions, different dates were fixed for different institutions. First off, the inspection dates which are scheduled on the date of election, which were scheduled on the date of inspection or within 2 days prior to the date of election or 2 days after the election will be allowed for inspection. Unquote. So stop. Next, learned counsel appearing on behalf of
Copy attached. No copy.
learned senior counsel slash counsel appearing on behalf of the petitioners have no objection to the decision of the DMET to reschedule the date of inspection accordingly. So stop. In such view of the matter is so in view of the as of the DMET as conveyed to this court through through Mr. R.C. Mohanty, no further direction is required to be issued in these matters, and these applications stand disposed of accordingly.
One item number 18. One case number is 1,800,179. The inspection date was posted to 18th. On 18th, he requested that the date may be adjourned. Now, on 17th, he requested for adjournment of the date. But on 18th, he requested for online inspection, which was denied.
So which item is this?
That is
Last item.
number 18.
Last item is telling. 60 is last item.
60.
Item number 18, my lord.
18.
Item number 18.
Item number 18, sub item.
Is the case number?
18171.
Eighteen.
Doesn't it come to the
Sub-item.
same thing? You had requested for adjournment, subsequently you got a
That is
separate order.
not for election, but on the date of repairing of the shop. So he requested on 17th to adjourn it, but on the date of the online inspection, he requested to conduct the inspection. But it was not allowed.
No, what happened?
My lord, the
Please
date,
give that list.
Yes.
Is it
the
covered?
date was intimated on 16th. That the inspection date is 18th.
What was the date of the election in your case?
No, election is not the question here.
All right, we want to know.
Election is 18th. 18th.
Is it copy attached? So they have not given you?
18th.
No, I am asking in your.
Yes, that is here.
Copy attached.
Some of the institution I am having with the list.
Okay.
This is which goes without saying that the DMET not differentiate between the institutions who have approached this court and those who have not.
Yes.
And extend them the same benefit as given to the petitioners in the matter of refixing the dates of inspection.
Those who have not approached also, you will grant them
Yes,
similar.
yes. But that is, if it's coming under that zone of
Yes,
consideration.
he is different.
Yes, it's different case.
But what was the date of your inspection fixed?
Inspection was fixed 18th.
And what was the date of the election in your case?
25th. May.
So your case will not be considered.
That case will be excluded.
He's saying
Yes,
no.
But on 18th, I requested to please online inspection.
How come you have kept it all together? It is a
No, my lord,
case.
these 18 item matters have come today. Those matters I don't have the copy. Recently, I have got the copy.
I have
the copies I have given previous list. That list I had. Item 18, most of
In
the,
your list, you have given that these are covered by this
yes.
without checking.
Some of the cases are covered, they have not justified. So we will consider, my lord, on this line, as per my lord direction, we will consider them.
Covered.
Yes, what about him?
My lord, I will get instruction.
Give him a copy. Have you given him?
I will get instruction later from day after tomorrow.
That will be on 27,000. That on that day.
Item
27.
Yes, my lord.
Minor, item 18, last sub item 111 for 2024. This is related to fresh NOC. My case is similar, my lord, but this matter related to issuance of fresh NOC, not renewal. Last item. 18.
18. Two cases, 18297 of 24 and 18302 of 24. Madam. In this was my ground is that this the debt to 3624 at 10:35. We waited, my lord. We document till 2:30 p.m. my lord. They did not. There was no on their side, my lord. At beyond 4 p.m. they again called us to appear. By that time, our staff were left.
It was online inspection.
Mr. Mahanti, you have not checked. We'll dispose of some of them will not get the relief.
No, my lord, cases.
Case is different.
No, my lord, only I have disposed.
18.8 or 18.9. 27. Have to check each and every case. Those matters will come on 27.
I beg your pardon to make one mention, my lord. The similarly situated two matters, my lord, could not be listed today. My lord, covered by your lordship's order.
My lord has already told. My lord has already told cover matters will come.
Automatically, all the matters will be covered. You just give the your case number. This will be listed under the heading to be mentioned.
Yes,
to mention.
grateful, ma'am.
Even if you have any other matter, if not filed a case, you take this order and.
Yes.
Oh, that's it.
Item number 48.
Item 48, regarding the Hindi teachers, because they are claiming that they are trained. Our case is that they are trained, but that is subject. And government criminals have trained them as one, right? After that, they does not fall within that formula that. I have congratulated the master directed that I will find a repeat.
Mr. Kuntia, I am not sure whether this covers this case. There is an interim order of the Supreme Court on July 17th regarding this Hindi teachers qualification. The order in Sulochana Behra has been stayed. Regarding this treating the qualification of Hindi.
Some cases that have happened that are reapplied and dismissed on the ground of limitation.
But there the Supreme Court has stayed on state has filed the SLP.
That means that honorable single judge order has been stayed. So those matters, some cases were dismissed here on the ground of limitation of the related Purmamanjari case.
Those cases are untrained. Those cases are untrained, dismissed by this honorable court only on delayed ground. This is the
case. They are saying they are trained. Our case is that they are not trained as per the last Contempt date. And on single judge are directed, even if they are not trained, they can be treated as untrained. So that provides a part. How can that they don't have that qualification? They are stipulated in the arbitration. This is the case.
on the last day, on 1st of August, when I submit to your lordship, the lordship is directed to submit your notes of I have submitted obedience to the direction, my lord. I have submitted the notice of submission earlier occasion, which is flag X, my lord. Only I don't, my lord, submit only 4 paragraphs before your lordship in my some notes of submission with due permission, my lord. In my flag X, in my notes of submission, I have stated page 4, my lord, paragraph 8.1.
Yes.
Fine. For that, as per the notification dated 23/10/2014, by appellants, the date of application was fixed on 20/11/2014, and subsequent amendment notification dated 13/1/2015 has also stipulated that the date of application, that is on 28 January 2015. However, the state appellant issued a corrigendum on 6 January 16 by fixing the last date of application on 22nd January 2016. Pursuant to the corrigendum dated 6 January 2016, the appellant further issued a announcement of contract teachers in government high school, upgraded high schools on 7/1/2016 for the year 2014-15. The said guidelines dated 7 January 16, pursuant to the subsequent corrigendum of 6 January 2016, wherein it is specified in paragraph 4, which relates that the eligible in all respect as per eligibility criteria fixed in these advertisements. For better appreciation of this quoted, my lord, paragraph 4. Earlier, the Director of Secondary Education Odisha had published advertisements on 23/10/2014 and 13/1/2015, inviting application for these posts.
What do you want to convey?
My lord, the subsequent guideline, it has been specified only those candidates who were eligible in all respect as per the eligibility criteria fixed in these advertisements. My lord, altogetherly, starting from 2014 until 2016, all these advertisements is specified.
Mr. Counsel,
My lord.
we are dealing with which advertisement?
My lord, advertisement initially 2014.
No. Presently, we are dealing with which advertisement?
My lord, 6 January 2016.
6 January 2016. We cannot see any other advertisement in this advertisement.
My lord, 6 January 2016, all the candidates and interveners has availed the qualification of trained BHED. Availed their qualification, eligibility qualification, trained BHED. B.Ed qualification, all the candidates has availed by 6 January 2016. That is why I am only indicate all those candidates specified these advertisement and guidelines published in the paper website, and by the last date of receipt of application fixed these advertisements. Along with all those advertisements, says the subsequent corrigendum of 7/1/2006 specified these advertisements. And another one was subsequent paragraph.
No, you are reading from your submissions, or you are reading the advertisement?
This is, my lord, I have quoted the paragraph 4 of corrigendum. Pursuant to the corrigendum of 6 January 2016, the guideline issued by the appellant authority on 7 January 2016.
No, when was the advertisement issued?
This is the guidelines issued 7th January 2016 in view of the corrigendum 6 January 16.
When was the advertisement issued?
In starting from the advertisement issued 2014, initial advertisement.
This selection process was undertaken after an advertisement.
Minor.
What is the date of advertisement?
The date of advertisement is 27/10/2014. First, initial date of advertisement.
All right.
There is another point is all the candidates rejected on the ground that the candidates has obtained the B.Ed qualification after 6/4/2015, which is been mentioned in the ground of rejection by the appellant here. There is no cut-off date. There is no mention anywhere of the advertisement that is the 6/4/2015. Where from the date the 6/4/2015, the
All right.
appellant get that.
We will have to hear you again.
Minor.
Where is the advertisement?
2014 initial, subsequently.
Where is the advertisement on record?
Advertisement here is.
Page 68.
Page 68, my lord, Annexure 1 of the writ appeal, my lord.
Mr. That is
Hello.
different thing altogether. According to you, on because the date was extended, and therefore you became eligible, and in the meanwhile you acquired qualification.
But does the corrigendum allow that? That in the meanwhile, if you have allowed, if you have acquired the qualification, that will be considered.
But there is one.
Mr. We had heard that aspect also.
Your lordship is right, my lord. I bind on your lordship's, my lord.
That was the age criteria was relaxed for those who could not participate in the process of selection. Because for so many years
my lord. That is why I am before lordship, my lord. There is in the eligibility criteria of the qualification, there is no specification of date by the date which the candidate must have.
That we understand, that we will deal with.
In that view of the matter, my lord, in the absence of cut-off date of the eligibility qualification, there the settled principle of law.
Counsel, you have stated that in your written notes.
My lord.
You are not required to read that.
My lord. And the another point, my lord, the rejection of 6/4/2015, the date, nowhere else the advertisement has been stated.
See, Mr. Counsel, patient hearing does not mean that you start testing our patience.
Only, no matter. Only
you have done, we have heard you patiently. You have, we gave you an opportunity to submit your written notes of argument. We will see your written notes of argument. If we find some merit, we will consider that.
Because of
what?
Because I have folded hand, my lord, because since 2015, these candidates, the overage, my lord, nowhere else, my lord, out of job. That's right.
Whatever even if you bow down, if you fold your hands, we cannot, we have to follow law. And even if you show disrespect to the court, still we have to follow law. If that goes in favor of your client, that will
only one minor. I am praying for also only submitting one minor, one paragraph. I have obtained the RTI application there. The
RTI, I don't know in this case or in some other case we are going to hold.
That is taken into consideration by the Leonard
RTI informations cannot be relied on for deciding, adjudicating disputes in writ proceedings.
Here is the similar situated person. Has engaged, he has engaged, my lord. But one hand, my lord, the authorities committed class within the class.
I'll give you.
Two persons, similar situated, similar educational qualification have availed the opportunity and benefited the contract teacher. They are engaged.
We are again repeating the same example.
Deeply obliged, madam.
That so many murderers could not be convicted. Therefore, if someone commits murder and gives an example that he had also committed murder and he got acquitted.
And boundary lordship,
That is not
the
the.
criminal case for here is the my lord,
All-
ye life and livelihood, my lord, this petitioners. They are nowhere to out of job, my lord. That's why. That's why before your lordship, I am praying before your lordship.
Give you, all right. Result.
And one IA is telling, my lord.
Do you remember I have dealt with somewhere?
That I have removed that I have gone through that. What has happened in that case, that point was argued on that constraint, but the lordship delivering the judgment, that part has not been taken into account because that alternative qualification. I have given that copy of the three documents.
No, I might not have, but I must have interpreted that.
Might not have.
I have not done. All right.
Justice Brahman has given that.
Mhm. Acha, that. All right.
On that point, your lordship has convention pointed that alternative qualification and they don't fulfill that qualification, they are not eligible.
All right.
Item number 26.
Persons for providing manpower services for their security and driver and all that. Now, may I kindly turn to Annexer 2, my lord. I am drawing the previous tender call notice. Annexer 2, page 29.
What is your prayer?
My lord, prayer is for passing of that tender call notice. In fact, the action of the opposite parties in going for this fresh tender call notice, in spite of, my lord, the petitioner who has been assured of extension or who had been assured of extension pursuant to a prior tender call notice.
How can someone assure you?
My lord, they for consideration. My lord, may page 29, Annexer 2. I'm just. This is the tender call notice for the similar for providing similar service. In fact, original tender call notice didn't provide for any period tenure of service.
No, you are challenging which?
Annexer 1, my lord.
Annexer 1 you are challenging?
Yes, my lord. I'm drawing a lordship attention to Annexer 2, my lord. Page 29. This is the previous tender call notice of the year 2020. Here, my lord, original tender call notice didn't contain any the tenure of service, the period of service didn't contain. Page 35 is the corrigendum.
So this is final according to you?
My lord?
This is according to you final?
No, my lord. In that, they have given that you will be granted for 3 years. If you provide better service upon certification, we can consider it for another 2 years.
Can.
Lord, I have no vested right, my lord. I have just a right of consideration. At least they should consider after having provided, my lord, I have engaged 61 persons. Those persons are there since last 4 years.
So you also participate. They may give you preference. If you are so good providing services, then they may give you preference.
Now it's a tender, my lord. They have, in fact, since 2020, I have been rendering that service. I have engaged, giving them the service of 61 persons, my lord. And on the basis of their, my lord, promised in a way that you will be providing.
Why don't you participate in this also?
I had not participated.
Then you are not willing.
My lord, my lord, in this writ application, I'm my grievance is they at least should have considered my prayer for extension.
No question.
My lord,
no question. And you have not participated, you are not willing.
Lord, in fact, I'm challenging, so I couldn't participate. If I
would have.
My lord, may I just rely on one? Sorry, my lord, I know it's a judgment of one. persuasive. Just to persuade your lordship, my lord, it's a division bench judgment of Honorable Patna High Court, which your lordship has headed the bench.
I
In a
cannot-
similar case, my lord.
What you are suggesting could not have been done by me.
Like in a similar circumstance, here also, you know, outsourcing, the government is outsourcing certain services and they have applied, they have, in this writ application, they come up for the extension. My lord. I draw your lordship attention to paragraph 12, my lord. Paragraph 12, the second paragraph, sub-paragraph.
No, that will depend on nature of work also.
In a way, my lord, the facts are
So this was-
almost similar. Because they are also in that tender call notice, they have a right of consideration for that extension.
No. This was regarding functioning of hospitals.
My lord, yes,
states and-
providing manpower services. I mean, providing services for maintenance and functioning of hospital. Sanitation, cleaning, lighting and laundry services.
Non-manpower.
My lord, yes, providing a service. I mean, outsourcing of that job.
The entire services.
Yes, my lord.
The entire services were provided.
In fact, here also lordship has denied that relief. I'm just your lordship's my lord, lordship has highlighted on the legal aspect of it. I'm just highlighting, but ultimately your lordship has dismissed that writ application. For that, the petitioner having not elaborated upon what investment he has made, for that your lordship has dismissed that. But I'm just drawing attention, your lordship, to paragraph 12, the sub-paragraph in that.
Yes, that.
We are, however, of the view that in case an agency to which the works enumerated in the said letter dated so and so are outsourced under an agreement consequent upon which the agency makes substantial investment and thereby puts in place equipments and other technologies for better management and efficient execution of the work awarded to it, the competent authorities should consider extending the period of contract if the work is not otherwise found to be unsatisfactory. This serves the public interest which has been acknowledged by the state government in its decision as communicated through
Paragraph 12 is the paragraph 12, the opening paragraph of that paragraph.
Yes.
First subparagraph.
Yes, ma'am, I'm placing that. Further, in our opinion, the said communication dated so and so is not in the nature of guideline. Rather, it enables and permits the competent authority to extend the period of contract awarded.
And according to your own submission, this is not binding.
No, yes, ma'am, it's not binding. Your lordship has in that case also the right to consider. They should at least consider me having provided, my lord, 61 persons I have since last 4 years. So they cannot overnight, my lord, throw me out and go for tender. After having given a certification that my performance is outstanding. My lord, till 2023, they have given the certification that my performance is outstanding. That certificates I have annexed, my lord.
So you could have participated, therefore. You could have participated, you had made so much of investment.
Yes.
That could have, if you had, don't know, the petitioner in the present writ application has put to challenge a tender call notice dated 15/7/2024 issued by the bank.
Yes, my lord.
Which bank?
Sundargarh District Central Cooperative Bank Limited.
Sundargarh
OP1.
OP1 for providing manpower resources to work in different positions at different places throughout the district. Full stop. Next, it is the petitioner's case that the said tender notice has been issued during the subsistence of the contract period between the petitioner and opposite party number one. And throughout the agreement period, beginning from 17/7/2020, the opposite party number one had duly certified satisfactory services of the petitioner. Full stop. Next, he submits learned counsel appearing on behalf of the petitioner has submitted that initial agreement was entered into between the petitioner and the bank on 17/7/2020 for a period of 3 years for providing manpower sources for different stations of the bank. Full stop. The agreement stipulated that the bank, that the opposite party one might consider extending the period of contract. Stop. However, without considering the petitioner's
Actual correction. For extending 2 years, they have extended for 1 year and not extended for the rest of 1 year.
So 1 plus 1.
Oh, ought to have been, they have only one, extended for once for 1 year.
contract for initially for a period of 1 year and further 1 year more. Stop. It is the petitioner's case that though the agreement was extended for 1 year, after completion of 3 years.
You had applied for 2 years, they extended for 1 year.
1 year, yes.
That way they have considered, that means.
Exactly. The default clause applies. Once they have applied that extension, they ought to have for 2 years, not for 1 year. That is my case.
After completion of term of agreement, that is 3 years, comma, on a request made by semicolon, which was done on request made by the petitioner for extending the period of contract for 2 years. Stop. Current counsel for the petitioner has relied on, has referred to division bench decision of Patna High Court in case of Indradev Singh Seva Sansthan versus State of Bihar, reported in 2022, volume 2, BLJ. Page is not there, 158.
158.
Stop. Next. Admittedly, the initial agreement was for a period of 3 years. Stop. There was no obligation on respondent number one to extend the period of contract. Stop. It was on the petitioner's representation that the period of contract was extended by 1 year. And thereafter, 1 year. Stop. It is the petitioner thus cannot have a grievance that his case for extension of the term of contract was not considered. Stop. he cannot have a right to claim that his contract period ought to have been extended for a term of 2 years beyond the original term of 3 years. So we therefore do not find any merit in this application, which is accordingly dismissed.
Obliged.
Item 27.
May I please list? Annexure 7, the impugned order issued by the opposite party number 3 is under challenge lordship, wherein the opposite party number 3 have desired the petitioner to participate in the tender process for a period of 5 years lordship.
Where is that? Where is the order?
That is Annexure 7, page 47, my lord. May I be permitted to read the operative personnel?
Where is the department?
Lordship, in the last paragraph, page 47, Lordship. Therefore, after careful perusal of the facts and terms and conditions mentioned in the MTF as placed before me, and without prejudice to any other right and remedy, hereby suspends owing India the present petitioner for 5 years from the date of issue of this order. Further, owing India shall not be eligible to bid for any tender in FCI from the date of suspension order, Lordship. So far as the factual aspect of this case is concerned, Lordship, the opposite party number 3 has floated a tender wherein I have participated for the annual maintenance of the OA bridge, Lordship. I am a partnership firm and duly licensed from the government.
We are issuing notice. Who is that? Issue notice.
See, I have filed an IA, Lordship. To another tender was floated and today is the last date.
No. Let them appear. Issue notice 1 week, 6 weeks. Make a mention after.
Published.
The order have been passed in February.
Published.
Item number 28.
Contempt.
Complied or not?
Not yet complied. Not yet complied. In course of the filing, I have given an affidavit that we have not complied your lordship direction that district cadre shall be created and this case shall be considered. And we have considered the case. None of the petitioners in the case have been found suitable because they have not passed the departmental examination. Accounts examination is mandatory for being promoted to that case. And that has been also held by the collectors. Their cases were considered. And it has been, now we have decided to send them for training so that they can be eligible for promotion. That affidavit I can file, but that we have decided. So,
where is the order?
This honorable court's order,
Yes.
my lord, page 37. Page 37, para 7.
Will be considered in accordance with the prevailing rules.
Yes, ma'am.
The rules prescribe that they must.
Orissa Ministerial Service Rule provide that they should have that training, departmental training, so that they can be promoted. My lord, in the last order, your lordship has already noted that prima facie the order passed by the division bench of this honorable court has not been complied with. That is why your lordship directed the labor commissioner.
So now they are saying that they have complied with.
No, it cannot be taken as a compliance, my lord, because under the rule.
We cannot see the rule.
My lord.
We will see the order.
My lord,
we will not go beyond this paragraph 7.
Paragraph 7,
So from paragraph 7, if you can demonstrate that there has been any violation.
yes, madam, that is what I am submitting.
So just come to paragraph 7.
There were two parts. They have direction was for framing the gradation list. They have done that part. The next part is the consideration of the case of the petitioner for promotion. Now the labor commissioner cannot wriggle out himself from the process of considering the promotion of the petitioner by simply passing on the responsibility to the collector, what is my learned friend is submitting. That is one aspect, my DPC.
No, first part has been complied
with.
Now come to second part.
Second part, my lord.
It is needless to say that if the vacancies are available.
Vacancies are available. Because
if the vacancies are available, the zone of consideration shall be created on the basis of gradation.
My lord.
So zone of consideration has to be created. And then persons in the zone of consideration shall be considered for promotion in accordance with prevailing rules with expedition.
With expedition.
Yes.
With expedition, that word expedition I am underlining, my lord. The order was passed long back. Till now, they have not complied with it. That is my humble submission. Consideration part I am submitting before your lordship. The labor commissioner cannot himself keep out of the purview by simply saying that the collectors have conducted the DPC. Under the rule, the DPC has the role of the DPC is only to consider and the case and send their recommendation to the authority. Here, the labor commission is the authority, cattle control.
We cannot go into that aspect of the matter.
My lord.
We just have to see whether they have been considered for promotion in accordance with prevailing rules or not.
My lord, all the petitioners have not been considered, my lord.
Why you have not considered?
No, my lord. In 3 cases, we have considered and rejected, saying that, my lord, 3 cases, because they are not found in 2 cases, they did not comply, did not consider him, saying that because they have not passed, they have given opportunity to go for training and thereafter they will consider that.
Where is that? File that affidavit.
You will also may call it tomorrow, I can file that affidavit.
Tomorrow we will take out.
Yes, let him serve me a copy and
Serve him copy. Proceed matter tomorrow, as requested by learned AGA.
Item 29.
Denying this contempt application for non-compliance of your lordship's order dated 2/11/2023, my lord. And after issuance of the notice, the municipal commissioner appeared and filed a review petition that for reviewing of the order which was passed in the writ petition. And your lordship directed me to file a reply to the review application. My lord, I am filing today.
File it in the registry.
Yes. And in the previous date also they did not appear, my lord. Before your lordship, they were not appearing, and your lordship, however, your lordship directed me to file the affidavit.
File it.
Yes.
First we will hear review and then only consider contempt. And counsel appearing on behalf of the petitioner states that he are we here? One counsel representing the respondents states that he shall file a review counter affidavit in the registry by tomorrow.
Yes.
Complete this matter 1 week.
Item 30.
My lord, this is a contempt application. The order passed by this honorable court is setting aside the blacklisting order and directed the authorities to reconsider the matter. Now, no time limit is fixed. So in law, of course, a contempt will not lie where a time limit is not fixed. Oswald says, 84 Supreme Court says, if there is no time limit, strict sense, no contempt is made out. But if the petitioner can file an application to fix up a time limit in that very matter. That is what Oswald says. If the lordship likes to see that, that's here.
The time limit you will have to apply for. fixing time.
Definitely, Lord, we'll have to apply.
So did you? Will you?
No, we have not yet. Lordship grants a liberty, I'll do that.
And counsel for the petitioner after some argument seeks permission to withdraw this application with a liberty to apply for fixing a time within which the order of this court from a violation of which has been alleged in the present contempt application, comma, should be complied with.
Yes.
So this contempt proceeding stands off accordingly with the liberty as sought. But why is this, Mr.?
No, but we are in fact in the process of doing that, Milos.
Okay.
I've taken instruction.
Black-
Within a week or two, they will do it, Milos. Today itself,
This is
I've talked.
Blacklisting.
Yes, Milos. Milos.
Item 31.
May I please, Your Lordship? The opposite party fails to comply the order passed by this honorable court on 29 February 2024.
Yes, where is the order?
Page 9, para 8. May I please?
What is the direction?
The direction is to pay the wages within 1 month. In disposing of the requisition, this court directed the opposite party seeks in extending the minimum wage benefit under the notification number 2015-2001 to enter into the calculation on the payment of area wages to the petitioner in terms of gazette notification issued by the Labor and ESA Department since 24/7/2000 and in the calculation paid to the at least last notification dated 2/11/2000 and find out the area required paid to the petitioner. The area as per the calculation following the direction of this court shall release in favor of the petitioner and at least within a period of 1 month, and the payment of area be made the petitioner within a further period of 15 days of the calculation. Failure of payment of stipulations, the petitioner will be candidated to get 6% per annum also.
The Sarpanch was implemented on that date.
Sorry, madam.
That date was disposed of.
So whether this writ application has been was disposed of in terms of some other order?
Yes, my lord. The Vijay Kumar Sahu versus Commissioner to Government of Panchayat Raj Department in WPC 6871, para 6, it is mentioned para 6.
Yes.
It's Sarpanch, Milos. I cannot take notice or see.
The Sarpanch and that too, Sarpanch has been implemented on that day.
Very day. So she might not be, he or she might not be aware of that order of this one because elected Sarpanch.
Let the notice be. Notice issued.
So notice. Yes.
Oblige. Requisite shall be filed with them.
Item 32.
32, Your Lordships. I'm on the virtual mode, Your Lordships. This was a matter where the order of punishment had been quashed by the State Administrative Tribunal. Further, the state had filed a writ which was dismissed, and Your Lordships, in fact, this bench itself had dismissed the review also. And there was a withholding of an amount of 3 lakhs and odd from the gratuity. That is all that was supposed to be returned to the petitioner. Until date, it hasn't, Your Lordship. It's been since 2011 he's filed this. The original OA was of 2011 and the punishment order.
Where is the order?
Your Lordships, the punishment order is at Annexure 1,
No,
page
not
11.
not this court's order.
Your Lordships, the review order, the last order Your Lordships will find would be at page 33. That's the last order where the state had filed a review.
Yes.
Yes. Pursuant to lordship direction, lords, the order has been withdrawn, the punishment has been withdrawn, and the amount that has been withheld has been directed to be refunded to him by the order dated 79/97/2024. Now, because the amount is to be paid by the AG, AG has been moved. In the meantime, we will pay the amount that is after obtaining from the AG. This is the instruction I have received. So some time may be granted so that I can pay the amount.
At the request of when AG is representing the contenders, list this matter on 3 weeks to ensure full compliance of this court's order, violation of which has been alleged in the present application. Yes.
Item number 33.
This matter, Lordships had already had and put up this matter for the passing of orders.
Order.
That matter where I had filed this writ application saying that the labor code had passed an ex parte order, even though for grounds your Lordship were not, but I had pleaded one thing, that he should not be paid the back wages. That your Lordship may consider disposal.
Tomorrow.
Lordship, may I, that last occasion, my learned senior said about he compared it with another case, but therein, your Lordship, 25F was complied with. Here in my case, it was not complied. That's why I'm playing for full back wages.
Tomorrow you'll pass out.
Obliged.
Item 34.
Appeals. Here in this,
You paid the amount.
I have with the draft. 2 lakhs plus not paid, 48 already paid.
2 lakhs we brought the.
Yes, ma'am. And who doing that interim application?
There is Mr. Raps.
Mr. Ramakant.
I put there.
Yes.
There is a specific order is there, failure of the payment minor. At page 21 minor.
Within stipulated time, not paid.
In my contempt application, I have annexed the order passed in matrimonial appeal 38.
Getting interest.
No, direction was given to
Even
pay
the
within 6 months.
compensation as directed to be paid shall not recover from the respondent of matter 3821 only if the payment is made within the stipulated period. In the event of default of payment in terms of our direction, the said compensation amount shall be paid by the appellant matter 3721. There was a direction in DV proceeding minor. There was a direction to pay 20 lakhs to the wife. There has been considered, and when stipulated by this Honorable Court permanent alimony, that has been excluded. And when the direction, if failure of the payment, then the DV compensation would be paid.
Where?
Well, finally, sheet 21, page 21. In my contempt application.
Amount shall be paid by that.
Where is the order?
Well, order is annexure 1 in my contempt application.
Page 7.
Page 14.
Running page 14.
In my contempt application, page 14, annexure 1.
Order.
Relevant page is 20, paragraph 11.
Which annexure is the order?
Annexure 1. Paragraph 11, page 21. Thus, having interaction with the counsel for the parties extensively, we accept the claim of the applicant matter 3821, the wife, and we settle the permanent alimony rupees 80 lakhs to be paid by the appellant matter 37, the husband. The appellant matter 3821 shall receive the amount that has been invested the State Bank of India in the name of registered judicial High Court of Orissa. The remainder of the amount of that is rupees 50 lakhs has to be treated as outstanding and that amount has to be paid by the appellant matter 3721 in 2 equal installments. First installments of rupees 25 lakhs shall be paid within a period of 3 months from today, and the final installment of rupees 25 lakhs shall be paid within a period of 6 months from today. The entire outstanding amount as noted above shall be paid either in the form of demand draft, or the said amount can be directly transferred to the bank account of the appellant matter 3821. We would request Mr. Saul and a counsel appearing for the appellant matter 3821 to supply the bank details of the appellant Mr. Rotho, and counsel appearing for the appellant matter 37 in the courts of today. Here the permanent alimony is settled finally. No future claims would be raised by the parties. That apart, they shall not interfere with their individual life in any manner. In the result, the appeal being matter 37 is dismissed, and the appeal being matter 38 is allowed to the extent is indicated above. Then the conclusion, paragraph 14, madam. It is made abundantly clear that no further maintenance allowance the appellant matter 38 of 21 shall be entitled to in terms of the order passed in criminal miscase of 550 of 2006. That is my defect order.
So
Even
he is ready to pay, he is paying.
well, he is ready to pay only 2 lakhs. Here is the
And what about 50?
48. I have paid.
48 has been paid
48 has been paid.
and 2 lakh he is paying.
That has been paid, but within the within the time.
Huh?
Within the time specified time.
So 48 has been paid within
48
time.
is paid.
2 lakhs.
Paid within time he is paying. He is paying further amount.
But there is a specific order.
All right.
It failed within the time. Then the appellant,
So fell substantially paid, only 2 lakhs was not paid.
Not paid.
He is paying.
And probably he had filed an IA for clarification. So after we clarified, he is paying this amount.
Wouldn't that?
After receiving the notice of the contempt writ application, they have approached before this Honorable Court of through IA for clarification. And on intention that the interest amount would be favor in his.
All right, you may take that.
Right.
You may
Because
take-
of minority, there is delay, and the husband is
That we have understood.
salary is at 11 lakhs per month. That is why the compensation amount passed in criminal miscase, that would be considered minor.
Yes.
Some of the amount is purchased.
Indeed.
There is violated the order. Right?
Present contempt application has been filed. Filed by the wife, alleging disobedience of this court's order dated 25/4/2023 in MATA number 38 of 2021 and MATA number 37 of 2021. The operative person of the said order reads as paragraph 11. So stop. It is not in dispute that a sum of rupees 48 lakh. 48 lakh.
Yes. 48 lakhs.
Was paid to the petitioner in terms of this court's order.
Right.
So the petitioner had filed an application seeking clarification, because of which the remaining amount of rupees 2 lakh could not be paid to the petitioner. So suppleant counsel appearing on behalf of the petitioner, on behalf of the contender, has handed over a check.
Draft.
To a demand draft. For
2 lakhs rupees.
what? 2 lakh drawn in favor of
My lord, petitioner,
huh?
In favor of the petitioner.
petitioner, contempt.
Uh, in favor of the petitioner, which has been handed over to London Council for the petitioner in course of the demand of litigation sale. Demand of, please give the demand of.
Give the Xerox copy.
You have a Xerox of it?
Yes.
Give that to me. It's a record.
London Council for the petitioner has, however, drawn our attention to the observation made by the court in paragraph 14 of the said order and has submitted that apparently the contender did not make payment within the stipulated time. And therefore, it cannot be said that the contender fully complied with the court's order. Stop. Next, in contempt jurisdiction, we are not inclined to entertain the petitioner's grievance for the reason that out of 50 lakh, 48 lakh was paid to some of rupees 40 lakh, 48 lakh was paid to the petitioner within time, and 2 lakh was not paid because the petitioner has made an application seeking clarification from this court's order. So, in such view of the matter, no case of intentional disobedience of this court's order is made out. Stop. Accordingly, the contempt proceeding is dropped. The IA, what is IA?
It is for clarification of ordering the time.
IA number stand in the MATA number. Yes. Stands as well. Yes.
Item number 35.
I can receive the demand draft. I can receive the demand draft. Demand draft.
Demand?
Steady mind.
Take it.
Yes.
You receive.
Take it, take it. The record, you can record in order when you
फाइल है ऑर्डर शीट है ना इसी को देखो ऑर्डर
we have recorded that. We have recorded it. All right.
Order is shall be recorded. I have received it.
Item 35.
May I please alert? In this case, I am appearing for the sole respondent, my lords. There is a delay of 496 days in filing this writ appeal, my lords. I have filed my objection, my lords. I have served a copy to my learned senior also. But in the objection, my lords, I have filed 2 orders of your lordship, my lord, wherein your lordship was not pleased to dismiss application, which was but 386 delay, 386 days delay and 324 days delay. Your lordship have dismissed. So here is a case where there is a delay of 494 days, my lord.
Lordship may say page 48 in the order. Your lordship already in similar. I am giving them. Same order is at page 48.
Yes, same order.
But that much here, when there is no, there is a delay of 500 days. That is my only submission. Right?
Maybe. Maybe let the decision of Supreme Court come.
Similar matters are posted to 28th, so
20,
posting it to 28th.
20. My limitation.
You received a copy of the appeal memo.
Yes, ma'am.
So on 28th it will come.
But your lordship is inclined to condone the delay, ma'am.
No, in that case, we have not condoned the delay.
No.
Yes.
That the order that they have.
It will all be heard together.
Yes, ma'am. In that case, earlier that delay was condoned. Subsequently, after condonation of delay, this order was passed.
Okay, in this case, delay was condoned.
Yes.
Oh.
Subsequently, this order was.
Consider your case for delay. Condonation.
That was the order passed in that Patita Pavan Datta case. You also can find it page 50 of my writ appeal. Relying that Patita Pavan Das case, this order was passed at page 48. May I read my? It is contended by learned counsel for the petitioner that the issue involved in this case is analogous to one involved in WPC number 19951 of 2020, which has been allowed on 9/9/2000 of this code. Therefore, in view of the reasons stated in the details of these writs are disposed of. So this was disposed of in terms of the order passed in that Patita Pavan Datta case. That has been challenged before the Honorable Apex Court. That was challenged in writ appeal. That was dismissed here. Subsequently, it was gone to Honorable Apex Court.
We'll consider at the time of admission.
My only one, yes.
Question of limitation. shall be considered at the time of admission.
Grateful, my lord. But what my learned senior said that the delay, the order that my learned senior had just produced, my lord, I was just verifying, my lord, there was no delay pointed out by the registry. So therefore, my lord, this case, there was no delay. And in my case, there is a delay of 500 days.
So we will hear this. Along.
Yes, yes. Yes.
Sir, question is you may have to address on that also.
Yeah.
That if common order judgment is delivered
Yes.
in a batch of cases and that judgment is set aside in one of the cases. All right. So whether other appeals can be dismissed on the ground of them being barred by limitation. So a judgment which could not sustain the test of legality, either that can be allowed to. That is one of the questions that may arise.
28.
Item 36.
Grateful.
Why have you come in this, Mr. Mishra? CMAPL?
But here actually, Mr. Ashok Mahapatra, senior advocate who died in COVID, suffered from about 4 or 5 months in the hospital and died. He was the counsel in this case. Unfortunately, his name didn't appear when the matter was listed on 19/7/2018. So he couldn't attend the case. It was dismissed for default.
So this is for restoration.
Restoration application, this is the restoration application, in fact. I filed this application. During COVID, actually, nobody could take any steps. He made the counsel, his office was in a disarray.
So restoration of what? 1990?
Restoration of the AHO, which has been dismissed for
Restoration of
default.
the AHO or the CMPL?
AHO dismissed for default.
AHO was dismissed in 2018.
18.
COVID 2020.
No, 18, his name didn't appear. So he couldn't know. So the client actually in 2019 February met actually he's one of his associate, and he said that yes, it has been dismissed on verification of the record. The 19th March itself, the COVID continued, so nobody could take any steps. And after that, when the client came, Mr. Mahapatra was no more there, so his office actually couldn't do anything. So thereafter, he was also suffering the persecution of one.
AHO is what? Yes,
He was the president of the bar and also very renowned advocate. Unfortunately,
who is for the other side?
Sir, Mr. B. Patnaik, Mr. S.P. Babu and Y. Mahanti, they are actually appearing in the AHO. If your lordship will ask, I'll serve a copy on them.
No, for whom?
For whom all the respondents for it.
Issue notice. All right, then serve a copy, then come.
Also.
Tomorrow we'll take out.
I'll serve.
Tomorrow.
Item 37.
How much delay?
But this present rate application, my lord, is filed in respect to the order dated 29th November 2023, my lord, passed by the Honorable Single Judge in the WPC number.
How much delay?
Like that 10 days delay, my. Actually, my lord, there is a delay in applying for the certified copy and the receipt. That is the only delay.
Yes.
Item 38.
In item 38, my lord.
So correction for order number.
Well,
Why is this happening? Order number one is typed wrong.
The correction there.
So because one was 5+4, serially everything has become like that.
It looks very good.
38.
The office has pointed out that order number 1 has been inadvertently typed as order number 4. Order number 2 as order number 5. Order number 3 as order number 6. So let the item of the order number be corrected accordingly.
Yes. I can request my lords to see the previous order. State government had taken time for a resolution of the problem.
Yes, ma'am.
He wants some time.
You want time?
State probably is seeking further time.
The matter, sir, will be resolved at the our
We
levels.
also hope so.
Yes.
Unless it's matter on. How much time?
2 weeks.
2 weeks.
2 weeks. Within first 5 business.
Item 39.
Yeah, please, your lordship. 22 delay has been pointed out by the registry in preparing the appeal.
How much?
22 days. In fact, your lordship, grants to para 4. So the order was passed on 19/4, it was uploaded on 25.
Item 40.
The delay is 40 days.
Item 41.
Please, my lords. My lords, I have filed an IA for amendment.
No, it should not be.
40.
Mr. Das?
Miller.
No, there's another. Your case, we can see there's a private party, but the previous one? 39. No, there are 3 Mr. Dases here.
So I'm 39, I am there.
Yes. So this is against a private party.
Notice to go.
Notice will go, Mr. You should have pointed out. You are there to correct our mistakes.
The requisite within 2 days.
In my case also, there is a private party.
Private.
39 and 42.
So 1 week.
Item 41.
My lord, I have filed an application for amendment, that is IN number 280, for deletion of the state of Odisha. And this is a matter of Union of India. By mistake, I have quoted state of Odisha. Kindly.
Which one?
41.
41.
For restoration, there is no state. No.
Kindly allow, I'll file a consolidated cost.
Petition has been filed for amendment in the cause title. Government Council for the International Subjects that inadvertently state of Odisha. Yes. And its officials have been imputed as parties
Union of India.
instead of Union of India. No problem. So it will be of the matter, this application is allowed. The prayer for Government Council for the petitioner is permitted to amend the first title of the application by substitute, right?
Consolidated.
By filing consolidated first title.
I'm appearing for none of them.
My lord may be permitted to submit. Short date kindly.
Shorted for what?
Listing of the matter.
Listing will come. Listing for that you'll have to make a mention. So otherwise, the lawyers will intentionally file defective application. And when the defective applications are filed, they may say that it will. You'll have to make a mention separately.
Item number 42.
42, Your Lordship, this is a matter where the pleadings have been completed. I'm actually unwell today. That's why I'm at my
In
residence.
in this case, I am for the
tomorrow.
opposition
Can it come tomorrow? Your Lordship? Tomorrow.
Here, my lord, in fact, my lord, may can see the order dated 8/1/2024. Well, what was the contention of the petitioner? Well, there is an allegation that his representation under Annexure 9 has not been considered. So, your lordship may direct.
But your colleague is not well. He is seeking adjournment on that ground.
Just tomorrow, Your Lordships. Tomorrow, even the first 5
I have
matter.
filed 2 applications for vacation of interim order, my lord. For that reason,
I'm just tomorrow, Your Lordship.
1 day. He wants adjournment of 1 day.
No, I am not. If he is unwell, she is unwell, I cannot stand on the way. I cannot say also. But I am the successful bidder. I have been paid everything.
All right, I have requested on behalf of the petitioner, discuss matter tomorrow under the same heading. Top plan counsel for the parties shall be at liberty to make a mention. In the event the matter is not taken up in usual courts tomorrow.
Obliged, my lord.
Obliged.
Item 43.
Small modification, my lord. Order dated 10/7/2024, my lord. Instead of opposite part number 4, the opposite part number 5. The order dated. In the read petition, there are 4 opposite parties.
All. There is a typographical error in the order dated 10/7/2024, wherein opposite party number 5 has been typed.
Wrongly 5 pages, 4. 4.
Has been typed in place of opposite party number 4. So stop. Let the said order be read accordingly, along with the present order.
For admission, item 44.
Name, please, my lord. My lord, this is the matter regarding disability pension of to an army person who has been discharged from army on medical ground, which is being held as aggravated by service condition and has been assessed at 30% for 2 years. And my lord, I challenge the impugned order dated 30th March 2011 of the Honorable Armed Forces Tribunal, who has allowed only the pensioner benefit only for 2 years, which is placed at Annex 12, starting at page 87. The operating para is at 22 at 97, my lord. At the same time, I have challenged the impugned order dated 6th February 2006, which is placed at Annex 5 at page 48, my lord, that on the basis of the this opinion of the medical advisor to the pension sanctioning authority, who has no local standing, because that position has been abolished since 2004, which I came to know from the judgment of the Honorable Armed Forces Tribunal, where this cited the letter dated 25th April 2011, wherein he stated that the post of medical advisor to pension is abolished in 2004. However, on the basis of the opinion of the medical advisor to pension dated 6th February 2006, this disability pension was being rejected, because initially the disability pension, the invalid medical book, held the disease non-psychosis disorder is being aggravated by service because of the strenuous training in the military service, which is being assessed at 30% for 2 years. And in keeping with the regulation 173 of the pension regulation for the Army 1961, he is entitled for the pension. However, after 6 years, the documents in respect of the petitioner has been forwarded to pension sanction authorities, and the pension sanction authority to take another 3 years. Then only I could approach this tribunal court under external jurisdiction, because 9 years I was just I was a street beggar. I was not granted any type of pension, my lord. And so, while the matter was sub judice before this honorable court, this the pension section, the OIC records rejected my pension on 6/2/2006, my lord. In keeping with that one, this honorable court disposed of the writ petition with the liberty to file the appeal. Consequently, I have filed the appeal in keeping with the advice of the OIC records. Thereafter, the first appellate medical board held, wherein it is held that it is not connected to the service, which has overturned this. This is the pre-just. So I am before Lordship, though I am providing second copy, since the matter is admitted by the honorable single judge. So I am providing second judge's copy, that's counter affidavit of the OP number 1 to 4, and also my rejoinder to that effect, and also counter affidavit by the OP number 5, and also I have not filed this rejoinder to that effect, because after getting notice, the OP number 5 had dispersed the invalid benefit, my lord, on 10/10/2017. The second judge's copy, my lord.
Has anybody appeared for the opposite side?
My lord?
Opposite party, has anybody appeared?
So
Union of India?
Because it is 2013 matter, land DSC has to appear, my lord. So earlier Mr. S.K. Patel was appearing. Thereafter, Mr. Anil Doy was appearing.
Every day different CGCs. Last date, Miss B. Sahu.
You're for the Union of India.
No, I am for the petitioner, my lord.
Every day, two councils are appearing for one party, Mr. Samantre.
Huh?
Two councils appearing for one party. Today, there is nobody for the Union of India.
May intimate the one of my friends now.
And this matter was also coming last week. And also he has to be conscious enough. And since the petitioner is
The disability pension has been allowed. What is your grievance?
My lord, it is only for 2 years, my lord. May I take your lordship's kind attendance to page 97
Page 97 of what?
of writ petition, my writ petition. Because
What is there?
I am placing before lordship. In the result, the application is disposed of on the contest, but without cost. It is ordered that the petitioner is entitled to get disability pension at the rate of 30% from the date of discharge from the military service up to 2 years from the date, and he will not be entitled to any further disability pension beyond that date. The area amount, as may be calculated as per this order, shall carry interest at the rate of 8% per annum from the date of the filing of this writ petition till the date of actual payment. The authority concerned is directed to implement the order within 3 months. Thereafter, my lord, it is only for 2 years he has been given out around 57,000.
Under which law you are entitled for this pension for the whole life?
But to that effect, that's why I am pressing for lordship. This annexure 1. Annexure 1 is the initial medical board. That is the invalid medical board.
Still under which law you are entitled for
173, which I have quoted in my para 19, my lord.
You don't
And also the opposite party also filed a counter affidavit, and also in this R12 also at page 47.
Mr. Counsel, please understand the limitations of our understanding also.
My lord.
We want to see the law. Let us see the law first.
My lord.
Then make your submissions.
My lord. That's page 47 of the counter affidavit. This is being
Counter affidavit of opposite parties
Yes, my lord. OP number 1 to 4, my lord.
filed on. So there is one filed on 5th April 2015, that one.
This is I am received my honor on 5/4/2016.
That one only. Counter affidavit on behalf of the opposite parties. I, Lieutenant Colonel
Yes, my lord.
Balbir
They
Singh
have
Chaudhary.
mentioned it is opposite party,
Balbir
but
Singh Chaudhary.
my lord.
You don't have the book with you.
My lord.
Do you have the book?
Yes, my lord.
So
I
let
am
us
placing
read.
before lordship. I have also quoted in para 19 of my writ petition as well as I am placing before lordship. But regulation 173 of the pension regulation for Army 1961, my lord. Individual discharge on account of their being permanently in low medical category. Individuals who are placed in low medical category other than E permanently and who are discharged because of no alternative employment in their own trade, so category suitable to their low medical category could be provided, or who are unwilling to accept the alternative appointment are discharged before completion of their engagements shall be deemed to have been invalidated from the service for the purpose of entitlement rules laid down in the appendix 2, my lord.
192.
190.
And 173, that is a primary condition that unless otherwise specifically provided, a disability pension consisting of service element and disability element may be granted to an individual who
Please
is,
give us your book.
Extract of para 173.
my lord.
Page 190, annexure some RX, that one. Running page 190. R. One 173, that
My lord.
provision you're reading.
Yes, my lord.
But in the counter affidavit, they say that it was not proved that it is.
That is the only reason. That's initially the Invalidity Medical Board held on 14 January 1997 that my disability was aggravated by service condition and 30% for 2 years. And subsequently, consequent the rejection by the OIC records by the recommendation of the medical advisor to pension who has no authority. And that is the first appeal medical board was held.
So this is the reason why this writ petition is pending since 2013. Because you are not making the court, giving the court opportunity to understand.
My lord, sorry, my lord.
This matter is pending since 2013 because of this. So you fall in which category? There are 5 categories.
My lord.
So you fall in which category?
My lord, the category it is not mentioned in the invalid medical board. May I place your lordship the annexure 1.
Mr. Counsel, according to you, you fall in which category? Medical board might not have
medical
mentioned.
Category E, my lord.
Medical category E.
My lord.
All right.
Your lordship can have glance. Annexure.
So read category E.
My lord, here your lordship can.
Please read category E.
My lord. My lord. That is not the category E, my lord. That's I am been invalidated in medical category E, my lord. May I take your lordship kind attention to the page number? Because in so far the army authority is concerned, there is A, B, C, D, E.
You were in army?
No, no.
Before joining the legal profession?
No, my lord.
No. All right, please come. Please show us from the book. Your disability falls in which category?
According to you.
My lord. My lord, B category. B category.
B category.
B category.
You may
I'm
be right.
touching before lords.
So you are not in E. You wrongly said E.
But here it's I mentioned this E. I have discharged on medical category E. I am placing before lordship.
E.
E.
You are placing E.
No, my lord, sir. I am category is E. Because I am category E. That is the only because in the discharge book, I mentioned it is category E.
No, you mentioned means in the book it must have been mentioned E.
Mr. Please be kind to us. Please, according to you, you fall in which category?
I am in E category. In E category. I am E category.
Very good. Please read E. Please read E loudly.
This is the provision. My category, whenever I was discharged from service, it was category E.
So suppose E refers to death, then you have died.
No, my lord.
No.
E means not fit for military service.
So please read E first.
But here itself, it is the definition of different categories under which a person can be invalidated out of service. That is different because this
Please
is
read E.
My lord, so far this is the category. That's why your lordship have to bear with me because the new concept. Because disability pension, a person can be invalidated.
We will permit you to teach all the concepts which are there in your mind, but please read E and tell us whether you fall in category E or not.
No, my lord. Here it is not on that category. I am not falling. My lord, I am discharged in medical category E, but in the medical so far whether it is attributable or aggravated or not, so it is comes under category B. So I am placing before lordship the annexure, where it is mentioned category.
All right, you file your written note of argument.
My lord, I have already filed my written note of argument.
You have already filed?
Yes, my lord.
All right, order is done. Right.
My lord, may I take your lordship kind attention to page 39?
Sorry.
My lord,
we have our own limitations. You have filed your written notes of argument, you will see.
My lord, may I take only kind indulgence?
No, nothing.
Page 39.
Nothing, sorry.
My lord, page 39. May I take your lordship? Page 39, my lord. Here it is category E. It is mentioned category. Page 39, my lord. Page 39, my lord. So my annexure to page 39, my lord.
You must have mentioned everything in your written notes of argument.
With this, so far your lordship posed the question. So with regard to E, it is not mentioned anywhere else. I have rejected my disability pension because it is held as the subsequent as the invalid, that is the appeal medical board, as neither attributed nor. But your lordship can have plans. May I take your lordship?
Yes, invalid, board out under AR 13, that one.
No, my lord. At the 39, at page, at the bottom side, right corner. Medical category.
Yes.
It is mentioned E. E. Your lordship got it?
No.
Page 39 of annexure 2 of my writ petition.
Yes, E. Yes.
This is the E. E means it is unfit for military service.
All right.
So far this category, different categorization is concerned, that is A, B, C, D. And the difference, the medical board has to ascertain under what category he has to be assigned. This is E. So my humble submission before lordship, the counter affidavit, they have raised jurisdiction issue, though I have pointed out, rather I have filed.
Simple question we are asking you, as per your assertion, what category should you fit in?
This is
for getting
category
military.
E. I was discharged in category E. However, in medical category, they have stated that this is the disease, that non-organic psychosis is aggravated by service condition. Your lordship can have learned this annexure 1, the initial medical board. That was
No, but not initial. We have to go by the final.
That final is subsequent to the this opinion of the medical advisor to the pension, which is being abolished, my lord.
All right.
Your lordships, if I may
yes,
require your indulgence. Lordship, there's been a violation of the procedure established by law, your lordship. The procedure regarding giving a disability pension as per the rule is that first the initial board proceedings, they'll pass the procedure, they'll pass the files to the officer OIC. Then OIC sends that to the PCDAP. Now, your lordships, until 2004,
the rule was that the OIC will send that to PCDAP, and PCDAP, after taking the advice of the MAP, which is the medical advisory pension, then they decide as to who will be, if he's getting pension or not. Post 2004, there has been a change in procedure, your lordships. The change in procedure, as already your lordship may have a look at the counter affidavit, para 5, where it clearly mentioned that in 2006, despite the abolition of the position of MAP, they have taken, the PCDAP has taken the advice of the MAP and then passed the ruling. So, lordship, my humble submission before lordship is that under Article 21, no one can be deprived of life or liberty except according to the procedure established by law. My humble submission before lordship is that the procedure which was there until 2004 has changed post 2004.
When were you discharged? When were you discharged?
13 February 1997, your lordship.
All right.
And your lordship may have a look at the annexure 3 of the counter affidavit, where it's clearly mentioned that taking the advice of MAP. And your lordship may have a look at the right corner where the date is mentioned in the 2006. So my humble submission is that they have not followed the due procedure, which is a violation of the Article 21. I have been deprived of Article 21 of life and liberty, as they have not followed the due procedure.
All right. Thank you. Thank you. You are Mr.
Rahul Pradhan.
Mr. Rahul Pradhan. All right.
Item 45.
May I take your lordship's kind
Lordship,
indulgence?
your lordship,
This is the document, the judgment wherein it is reflected.
Your
Yes,
lordship,
Mr. Pradhan. Give it.
lordship, the very argument that I made, your lordship may kindly have a look at the AFT order, which has shown, which has put in before your lordships as the what procedure has been followed post 2004. Your lordship may kindly have a look at the first para.
No, you relying on some decision?
Yes, your lordship. It is based on the rule is the procedure that I've mentioned before, lordship, is based on a decision that has been given by the AFT, Honorable AFT.
Oh, decision of the AFT, all right.
Lordship may kindly have a look at the para 1.
But unless you file it with a memo or something, it will get lost.
Your lordship may kindly have a look at the para 1 itself, where it says that the position of MAP has been abolished in 2004. Hence, my humble submission before your lordship is that the PCDAP has wronged in giving an order by taking the advice of MAP, the very position which has been abolished since 2004. So this is a violation of due procedure and under Article 21. Much obliged.
Item 45.
So I order dated 18/6/24. Lordships were pleased to direct me to inform this court as to whether the subdivisional officer Sadar Kotak was notified as the collector for the purpose section 5I of the State Abolition Act. And I have taken time. I inquired from the office of the collector. It is not also available in the office of the Board of Revenue. So they requested me to get it from the Department of Revenue and Disaster Management. If lordships can take it up.
Until you get that,
No, so I'm sorry.
you have to.
No,
If there is, how can you find something which is not there?
No, they say it's there, but they say that it's not available in the Board of Revenue, so they will get it from the office of the government, that
Or they
archives.
cannot create it.
No, can never be, because notification is of the year 1961, I think. 61.
So they will get, or you also ask the department also on your own.
No, I was contacted the office of the collector, of course. To be very honest, I did not talk. I can get it from the department also, not so within a day or two directly.
See, it is not that you have to get that. You have to have an answer whether it was there or not.
You're right, that is true.
Mr. Panda, it is there or not?
Yes, your lord, my lord. My lord, I am the intervener, lordship. Last occasion, I pray before your lordship to say something.
Is also
May I-
referring to that notification.
Notification as well as My lord, I have also got the book also. Kindly peruse
It's there or-
chapter 3 of the Odisha State Abolition Act, your lordship. Wherein the government specifically at that time, your lordship, 1960.
No, just a minute.
Order dated 29/7/25/6. 18/6.
Yes, yes. My lord. My lord, here, your lordship, in chapter 3.
So you are opposing him?
No,
Yes,
he is
I am
an
opposing to-
intervener.
I'm
The
the intervener.
villagers have come up in intervention.
Because that particular land belongs to the villagers and communal land is there. And they also,
So you must be opposing him.
yes, your lordship.
Yes.
Yes, your lordship. My lord, kindly peruse chapter 3 of the Odisha State Abolition Act. I'm placing your lordship. 14:1.
Yeah.
Chapter 3 of the
State Abolition.
State Abolition Act, page 13.
Yes.
Here, your lordship, in para 3, clause subclause 3, and Ancholo Sasana constituted under subsection 1 shall consist of Ancholo Sabha and Ancholo Adhikari. My humble submission before your lordship, at that time in the year 1951, the particular area, that is the Ramdaspur area, RI circle now, the Vidyadharpur comes under the Ancholo Sasan. And the Ancholo Sasan is the Tahsildar is the, they have a jurisdiction to pass any order under this act. Your
Why is the notification, sir?
Yes, yes. Coupled thereafter, my lord, in the rule, your lordship, in the rule, local action, there is a rule, your lordship, that is rule number, there is a notification, your lordship, number 11635 EA 11863R. Page, my lord, 78 in my book, my lord, 78. Local action. Notification is there, your lordship, rule. Rule, in rule.
Find out.
Yes, lord. Reference standard. And chapter 3 in particular. No, 1165.
1165. Comply with this court's order.
65 capital EA. Dot 1111 8/63R. Dated no February 63. 8/63. Dated 9th February 1963.
The interim order to continue. Interim order is there.
Interim order shall continue. See, Mr. The only question is whether subdivisional officer Cuttack was notified as collector for the purpose of
my lord.
section 5(1) of the Orissa State.
My humble submission. Serial number 4, your lordship. In the rule, it is specifically mentioned. My learned senior stated that he has annexed the matter. But my lord, that is in the hide. That is in the hide before your lordship. And serial number 4, subdivisional officer Athagoda Kotak district. At the Kotak district, that Athagoda subdivision Kotak district comes under this notification. At that time, your lordship, the Ancholo Sasana is there.
Oh, what is the notification?
That is the notification, your lordship. My given the
what does the notification say?
notification says that, my blessing, your lordship. In pursuance of the clause D of section 2 of the Orissa State Abolition Act 1951, Orissa Act 1 of 1952, the state government do hereby appoint the following officers to discharge the functions of the collector under clause 1 of section 5 of the said act in respect of the area specified against each without prejudice to any of the powers of the collector of the respective districts or any other officer appointed as a collector.
This was when? This notification was issued when?
On dated 9th February 1963.
9/6/19. And here the order was passed when?
Thereafter, your lordship, the order was passed. I have got not the repetition, your lordship, but first order was passed.
No, 1970.
14/4/1976.
70, then he is right.
No, sir, this notification is not. Sir, I read, I have submitted it for lordship.
Mhm.
This notification says subdivision officer Athagad
Attigad, oh, yes.
of Cuttack district.
Attigad of Cuttack district.
But my lord, as per chapter 3 of the Act, your lordship, at that time, 1951, prior to 1951, prior to coming up this act, there is a Anchola Sasana is there.
Okay, order is the serial number which? The one notification which you are reading.
Yeah, that we had examined.
My lord,
That notification we had seen.
my lord, let my learned family produce.
That notification we had seen.
Yes, but there is a clearly mentioned in
Next.
chapter 3 to apno connection. So chapter 3 more. It's clear.
Item number 46.
Lord, item 46, my lord, I am only praying for not today, my lord. I'll file a short note. I already informed my other side also. My lord, I am not ready. Already informed to my friend from other side.
Item 47.
Item 47, my lord.
I beg to pardon, Lord, sir, that interim order may be continued. 36%. Highly obliged.
Item 47.
Item 47, my lord. I'm for the respondent, my lord, appearing through VC. I'm extremely sorry I couldn't appear physically, my lord. Can I request, my lord, if my lord can call this matter day after tomorrow?
I'm not.
With my lord's due permission. The conducting council is
All right. As requested.
Hello.
Respondent. Oh, peer for the petitioner.
No, I am for the petition.
I'm for
I am for the appellant. In fact, it is a writ appeal. I am for the appellant.
Respondent.
Your lordship may give a short date. I will pay.
Wednesday.
Short date.
Wednesday.
After tomorrow.
Wednesday. This Wednesday.
This Wednesday.
Oblige. Oblige.
Miss Pal, a senior counsel is appearing. You could have informed him in the first hour.
I'm extremely sorry, my lord. I was not aware of the
Aware of
displacement
what?
of mis-
Face of the bench.
No, no, my lord. No, my lord. Not at all. Not at all, my lord. I was not aware that the
All right,
senior
all right.
conducting counsel won't be available right now.
Right.
Extremely sorry.
Item 49.
I shall prepare a note sometime.
Prepare a note. Let us see whether any merit is there in the brief or not. Where is the order?
My lord, here I am not challenging any order. You just stand.
You have filed appeal.
No, this is not appeal, my lord.
All right. 49, that's right.
Stand Soirat, my lord. Leased out in favor of the petitioner. The source was not feasible.
Now I want back my money. Now they are saying that it is terminated. They have filed a counter, I have filed rejoinder. Therefore, I am saying a short date, I could not do it, I am sorry, my lord.
Had you filed for refund
I have demanded refund
within time?
within time. The source was not at all feasible. I will show my lord from the dates and the
I think you have a series of similar cases where sources are not feasible. You have gone and deposit money for those.
Let me try myself.
Similar.
Let me
Your advisors are similar.
let me try myself. And move furthermore, I am not an expert in this.
No, but we are
you appear
thinking
to
you
be
are
an
an expert.
So some time, my lord, also little bit time.
And you appear to be an expert in mines.
Beg your pardon.
As requested.
You appear to be an expert.
You appear to be an expert in mining matters.
Appear to be an expert.
No.
From your looks, we can say. All right. As requested on behalf of the petitioner, list this matter. When do you want?
2 weeks after.
No, not 2 weeks.
Oh, 1 week after.
1 week.
Item number 50.
Item number 50 may taken up next week.
Why exodus?
Mr. Misra is appearing, KP Misra.
Why there is an exodus?
Mr. Misra is appearing because he is.
Therefore,
Mr. Misra is here.
No, Mr. KP Misra.
Just say that.
KP Misra. KP Misra.
Yes, sir.
Can it be taken up next week or any day in this week also?
All right. If you want to be taken up next week, we'll take up next week. This is 2023 matter. As requested. All right. Every time you're. All right. Yes.
Item 51.
My lordship, I pray for short adjournment of this case because Jayanta Ratha is absent today.
Because?
Jayanta Ratha, senior counsel, he remains absent today.
You're mentioning as if he's a junior counsel.
No, but I have also filed the writ appeal, my lord. That is 1514-1528, 1515, challenging the order dated 13th October 2023.
Same order. Same order.
For the appellants, this is that matter where the Honorable Single Judge has awarded the writ petitioners 5 lakhs each, and we have been thrown out of our job. Your Lordship may recollect that batch case.
I am appellant.
My learned senior friend, Mr. Rath, appears for the respondents here. He has partly succeeded before the Honorable Single.
I am also for a respondent, my lord.
This is the case where we asked Mr. Deo to prepare which are the
Yes, we have got that.
category of
That's
cases.
ready.
And in fact, the last occasion, Mr. Roth had also taken time to give reply because you also heard us because the appellate side is concerned. In one case, Mr. Misra is appearing, the other case, I am appearing like this.
We are basically here to protect our jobs because only the irregularity they found that instead of the director, the additional director had issued the advertisement. That's the only point. Page 109 and 110, this is the operative.
So your writ appeals are the year 2024?
Yes, my lord.
When did you file?
My lord. 2020.
When did you file?
2024 I filed.
July?
Yes, my
July 2024?
My lord. That is writ appeal 1514 or writ appeal 1528, writ appeal 1512 of 2024.
When do you want?
I have challenged the order dated
When do you want this case?
after 1 week, my lord.
I thought you were saying after 1 year.
1 week, my lord. 1 week, my lord.
As requested, you are independent.
Yes, my lord.
Respondent.
We are for the respondent, my lord, not the intervenant.
May I request him to give the three numbers because they are not providing numbers.
Why are you concealing the number?
My lord, that is, I'll file a
Keep that
memo.
confidential.
Yes, Mr. Raj.
I will file a memo of this details of this case and I'll file it. My
Details means
case number and
this number is just you can mention also.
yes, madam. That is Read Appeal 1514 of 2024. Read Appeal 1514 of 2024. Read Appeal 1528 of 2024. Read Appeal 1515 of 2024.
151?
Last one is 1515, my lord.
1515.
My lord.
So copies also.
Since you will hear also those matters, can they supply us copy of the writ appeal so that we can see?
Not by limitation, no?
Limitation, yes, I filed a condonation of delay and I filed it.
No, but those appeals cannot be taken up with this.
It is,
Because your appeals are barred by limitation.
I have filed delay petition, limitation petition also I filed it. My lord.
The status is different. The status of your appeals and their appeals, that is different.
I have challenged the same order, that is order dated.
So therefore, the status is same.
Yes, my lord. I have challenged the same
Order after 2 years. You challenge the order after 1 year.
1 year. Not 1 year.
We will hear these matters first, then we will consider whether your
My lord.
appeal they should hear or not.
My
2 weeks.
2 weeks. Interim order there.
Interim order, sir.
Item number 52.
Item number 52, my lords, I'm appearing in the first writ application. My lords, I pray this matter be taken up next week. I'll file my rejoinder this week. I have instructions, I'll file my rejoinder.
My lord, I am appearing in the connected writ petitions, my lord, and I am also filing my rejoinder, my lord. Am I audible, my lord? I am appearing. I am Naveen Kumar, appearing VC.
But Mr. Kumar, you were here, I think, in the morning. You.
Yeah, because of other hearing, I had to shift to VC mode. I'm so.
Yes, there,
it's always.
VC mode in our state, or you have left our state?
No, I'm still here, but I had to.
All right. Just in a lighter way.
Yes. It's always privileged to appear before my lords. I am also filing counter rejoinder, my lord, and the
Item 52.
The issue is that whether the common cause judgment dated 2nd August 2017 should be applied to those cases and to reopen the past years, my lord. The demand is being sought to be made from year 2001 onwards on the basis of judgment which was delivered on 2nd August 2017. And the judgment is only related to iron and manganese ore, and it has been noted by the earlier orders of this court in Nimai Charan Das, that is the main item in 52, my lord, and it is being extended to other minerals. So that my lord will look into.
You are representing
I am
whom?
appearing in. I am appearing the third petitioner in the other three writ petitions, my lord. That 40383985.
Requested on behalf of the petitioners so as to enable them to file a rejoinder to the counter affidavit filed on behalf of the opposite parties. These matters on when? When do you want? 2 weeks? 2 weeks.
My lord, may have it in first week of October.
First week of September. We'll file our rejoinders in the meantime.
Second week of
First
September.
week of September. Second week, my lord.
Sorry, so 2nd of September, 2nd September, 2nd September.
Are there any interim orders?
September, my lord, because 2nd September is Monday. So I can come physically. 5th September is convenient to my lord.
Yes, any objection?
Today was Monday, you were here.
Yes, my lord. I have.
Any objection? No, not Thursday, 2nd September. Yes.
Okay.
Item 53.
Interim order to continue, my lords. Interim order to continue.
Interim order.
Pursuant to your lordship's direction, I filed an affidavit and that has not come on record, my lord.
May I please your lordship, my lord, I am suffering, my lord. My lord, page 16, item page 16 may be seen, my lord. Tender for 1 year, my lord. My lord, page 16 may be seen, my lord. My lord, for a moment, my lord, tender for the year 1 year is tender in year 2022. Now, in 2022, now it's only.
He's got an interim order from that.
No, my lord,
single judge.
what happens, my lord, what happens?
Why are you?
My lord,
Why are you so agitated? He has got an interim order in that single judge matter.
My lord, division bench matter.
So say yes.
My lord,
Why you saying no? Yes.
My lord, the division bench matter taken single bench obtain interim order. Therefore, my lord, is now continue. That too, my lord, page 16 may be seen, my lord. For a moment, page 16 may be seen. That is for 1 year.
When were you supposed to file the affidavit?
On 8th August, I filed, my lord.
Yes.
I mentioned with your lordship that matter, I have filed the affidavit. It has not come, my lord, on record. Your lordship, but tomorrow, day after
2 p.m.
tomorrow, I have no. Day after.
2 p.m.
Tomorrow.
Tomorrow, pata karna na.
No, that is what he is saying. So let us dispose it of his file, something like that.
Taken up 2 p.m.
If according to them, my lord, in fructose, that tender has no value, my lord. I have nothing to say.
Internal order is there in second place, for which no tender process will not.
Tomorrow we'll take.
Item 54.
Item 54, may I please, your lordship? Your lordship, in this writ appeal, the order passed by the learned single.
Mr. Das appearing for respondent 4, he has some personal difficulty, maybe taken up 1 week after.
No, but.
I wonder. Jenna, what is this matter?
Your lordship, it is a writ appeal against the order passed by the single judge in a review petition, your lordship, in which the appellant had prayed and challenging the order dated 10/4/2023, as per which respondent number 4, who has scored less marks than the appellant, was allowed to continue in the service of assistant section officer, your lordship. Your lordship, and such order has been passed by playing a fraud on the court, your lordship, by suppressing facts and taking that as a ground. The appellant, being a aggrieved party, had filed the review petition, your lordship, which was dismissed, not taking into consideration
Have you
these facts.
challenged the original order?
Yes, your lordship. In the review petition, your lordship. In the review petition, your lordship.
Now, have you challenged only the review order, petition order passed in the review, or both the orders?
Both the orders, your lordship.
In this writ appeal, or you filed 2 writ appeals?
1 writ appeal, your lordship.
So whether any appeal is brought by mutation?
Lordship, the petitioner had filed review petition, and the review order is within limitation, your lordship.
So what about this 10/4/2023 order? Yes, who is on the other side?
He's asking for time. Tomorrow.
Next week, my lord.
Tomorrow.
He has some personal difficulty, Mr. Das, may take next week.
As requested on behalf of the respondents. Let's this matter on 1 week.
Next case, Honorable single judge passed order on the basis of Patita Pavana Datta case, which has been challenged before the Honorable Supreme Court. Same has been stayed. My lord, this case is on sub judice. My lord, the next case 55 serial. Maybe
This is also sub judice.
because sub judice in the Honorable Supreme Court. Any other date?
Where are those matters? Are you when have you posted? 28?
Yes, my lord. 28.
Sure.
28. Lordship,
28 means 28 na 28.
Today, another matter, my learned senior Mr. Khuntia was producing that order.
Please, your lordship said
28.
28.
No, that is the problem. It's 28 or 28.
I'll just,
देख ले?
I'll inform.
Could you
the-
please
I'll
say-
inform the court master.
Can you mention one matter?
You have interim orders. You have
Interim order, my lord. Continue.
Ask. Interim order to
Item number 59, my lord. Senior Advocate Mr. Ashok Manthi has given his consent to argue the matter. He has just left, my lord. May I request the matter may be taken up tomorrow, my lord? Item 59.
All the matters will be
My
taken.
lord, I praise, my lord, let it subject to your lordship, my lord. 2 p.m., my lord, if it.
No, 2 p.m. See, the council, if a matter is urgent, you can make a mention any time. All right. See, if the matter is so urgent, normally mention should be made at 10:30. If according to you, the matter is so urgent that it should be taken up at 11, we will take up at 11. If it can wait for a day, we can wait for a day.
Relates to a breeze work.
It depends on the urgency of a matter. So tomorrow, if the matter is urgent and you are apprehensive that if not taken up, you will suffer, then we'll consider.
You must be first satisfied, then you make a mention.